Hello, everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's coverage, we continue our coverage of the Ethan Crumbley trial, as it appears that the state is about to close out their evidence. Seems like we only have one more witness from the state. Not sure who that is, but that's the direction it seems to be going. Then we expect the trial to conclude early this afternoon, and the defense to start tomorrow. Seems to be the direction things are heading. So this trial might be coming to a conclusion by next week, which is good for me. So, excellent. We'll see how that goes. My belly's not full because you guys deprived me. I haven't had time to eat. Because you guys deprived me of my lunchtime because I had an argument with you, which is mostly my fault. The car is not really considered an extension of the home. That's just not correct under typical case law. Yeah, the automobile exception is well known. So yeah, it's not really considered an extension of the home. Yeah. It's in its own category of thing. Sometimes in some states, it is considered an extension of the home for self-defense purposes, but of course that's only in that context. I don't even know if in that sense it's really considered an extension of the home. It's just considered in the same category as the home. The only time a car is really considered an extension of a home is if it's an embassy. Then it is, I think. But other than that, not so much. Is an RV extension of a home? No, typically not. RVs are typically treated the same as cars under the relevant case law in most jurisdictions. Also, you shouldn't buy an RV. If you need to know why, look at Steve Leto. They're just a disaster area. Don't ever buy an RV. Cops would search our cars every once in a while. Not sure on what basis they would do that, to be honest, but okay. I'd have to check out the relevant law. And yeah, that doesn't sound right, but okay. RV may be a separate dwelling, but it's on wheels. So typically the automobile exception applies rather than the home exception, absent some circumstances. Now, if the RV is on a permanent platform, right, so it's now a mobile home, then it would be treated as a home. So there's that. Is it moving down the road? It's probably a car. Is it on a permanent platform? It's a home. Is it just have wheels on it and it's not moving? Slightly more ambiguous.
Yeah, I'm not gonna be there. I'm just waiting to see what she
But don't buy an RV. They're just a disaster area. They apparently are, well, the biggest problem with RVs is they're not subject to lemon law, as Steve Leto, who is a lemon law lawyer, will tell you in excruciating detail, because he rants about it pretty frequently. So under lemon law, if your new car goes bad a certain number of times within a certain time period, the dealer has to buy it back, or the manufacturer does, more of the point. So if you buy a car and it has, I forget exactly what the number is, but like 4 major issues in 2 years, the manufacturer has to buy it back. But that doesn't apply to RVs. And so you wind up in these situations where people buy these brand new RVs, they're worth several $100,000 sometimes. They break down immediately, and then they spend the next 2 years being repaired, and then the warranty runs out.
Let me just send out a text and let you know that it's full.
Is Virginia and Texas much different with laws? Depends on what measurement you're making. I mean, the states are always more similar than they're different. The devil's always in the details. I really shouldn't have said that phrase because now I feel dirty inside. I apologize. It's going to be a while before I can say that phrase again. Big picture, the laws are the same pretty much in all the states. Big picture. I mean, they do derive from a common legal tradition, so there's a lot more similar than different. Except for Louisiana. Maybe Louisiana's an exception because they have a civil law jurisprudence, so I don't know what goes on down there. So Louisiana is a question mark, but for the other 49 states, they're pretty much the same. Who knows what the law in Louisiana is? I'm not even sure the lawyers in Louisiana know what the law in Louisiana is. I think Louisiana has the longest constitution in the world by quite a long way. Because they're a civil law system, so they wind up putting everything in their constitution. The constitution has basically what should be just bills. Like sort of like routine stuff, and it's in their constitution. It's a total pain in the ass. Louisiana does have drive-through margaritas. Yes, they do. Texas does as well, but not as many. But remember, it's not an open container because it's got a sticker on top. This is one of my favorite legal fictions of all time, right? So yes, we have they have drive-through alcohol bars in Louisiana and some other states to varying degrees. So yes, you can go to a drive-through and order a mixed drink and they'll give it to you in a cup. Now, they can't give you an open container because that would be an open container. So you know what we're going to do? We're going to put a sticker on it. We'll put a sticker over the straw hole. And now it's a closed container because it has a sticker. Yeah. Or we'll put it in a bag and we'll staple the bag shut. So now it's a closed container. Yeah. Yeah. So that's definitely a thing that's definitely a thing. Yeah. Now don't drink it till you get home. Don't drink it till you get home. This mixed cold drink. Don't drink it till you're not in the car anymore. Wink, wink, wink. Yeah. And of course, Virginia still has this oddity, to the best of my knowledge, where it's not open container if anyone other than the driver is drinking it. So Virginia has that little quirk in law, or at least did, which I always found hilarious. So as long as the driver isn't the one drinking it, you can have open container in Virginia. Is it open container if the straw is enclosed in my mouth? That's a good question. I don't know. But if you have the straw enclosed in your mouth when the police pull you over, I think they have pretty good evidence of you drinking while driving. So there's that. Open container may not be your most immediate problem. Yeah, the passengers can drink. Did I say it the other way around? As long as the driver doesn't have it. Maybe I said it the wrong way around. You know what I meant. Yeah, anyone other than the driver can have an open container. That's fine in Virginia. But no radar detectors. That's super illegal. And they're also very vicious in Virginia with speeding. They're mean.
Your Honor, calling People versus Jennifer Crumbley, case number 22279-990, FH.
Thank you, Marquise, on behalf of people.
Karen Donald, you have the people.
If the passenger's 12, your problem is an open container.
Okay, so
But you would have other problems if the passenger is 12. So no, it's still not open container if the passenger is 12. But you might be violating other laws.
set forward, so I'm going to remember about not doing that. I think they moved the camera over, so.
Open container in the trunk is not a problem because it's a separate area from the cabin of the car. The same reason why limo drivers can drive around with people drunk in the back. Because the driver's separated from the passengers by a closed partition, so it doesn't count. It's not in the same compartment as the driver. So yeah, a open container in the trunk is no problem. Also, Virginia doesn't have bars in the strictest possible sense, because the way that Virginia defines this and the way I think other states do for that matter, to the degree that they make it, bars don't serve food. So Texas does have bars. I went to a bar recently in Texas. They did not have food. So Virginia does not have a single bar because every place that serves alcohol must serve food. So Virginia technically has no bars. Technically correct is the best kind of correct.
I wanted to let you know that I think one of the video cameras got a quick look of someone of one of the jurors as they pulled forward in their chair. So I guess I'd ask you not to lean forward, but we moved the camera too. So, the name of the next witness?
Brian Malash.
Oh, Brian Malash. Okay. Could you step forward? Could you raise your right hand? Do you swear to affirm the testimony about the day was the truth, so help you God?
Yes.
Okay, could you step up and have a seat? And would you state your full name and spell your first and last name, please?
Brian Joseph Malash, BRIAN-MELOCHE.
Okay, so just keep your voice up.
Okay.
Go ahead.
Sir, you're a little soft-spoken, so I want you as loud as you can. Pretend like I'm in the back of the
Okay.
All right. And sir, how are you employed?
I'm full-time, my job.
Yes. What do you do?
I'm a full-time firefighter captain.
Okay. Now, sir, do you know James and Jennifer Crumbley?
Yes.
Not through your profession as a firefighter, but personally.
Yes.
Okay. Is Jennifer Crumbley in court today?
Yes.
Can you point her and describe something she's wearing today?
Yes, the gray blazer.
Okay. Would the record reflect identification of defendant?
Yeah, Texas doesn't have casinos, which is also strikes me odd.
She's nice and loud.
And Texas is currently having this Cold War on poker casinos. It's interesting because basically someone found a loophole and they've been exploiting it. And poker rooms are exploding in Texas, and the law on it's a bit ambiguous. But basically, as long as the house doesn't take a rake, they don't take a percentage, it's not technically illegal. And it was designed for home games, of course. But yeah, recently a lot of professional businesses are doing it. And they charge a membership fee to their members, which is legal. And they also charge for services like food and stuff, but they actually don't take a percentage of the pot. And there's a little bit of a cold war going on right now because some prosecutors are like, this is illegal. And so every once in a while, you'll read about a raid that went on somewhere. And so poker to stop being so there's a little bit of a cold war right now on poker halls. It's kind of hilarious. Yeah.
I'm even having trouble.
Okay.
Here.
Sorry.
Okay. When did you first meet Jennifer Crumbley?
High school.
High school? Okay,
Yes.
so you went to high school together?
Yes, sir.
When did you first meet James Crumbley?
When they moved back to Michigan.
Okay. So in between the time you knew Jennifer Crumbley in high school, from the time that they left the state and came back to Michigan, did you stay in touch with her?
No, not until maybe Facebook years, a long time later.
Okay. And you said you were connected with her on social media?
Yes.
Okay, so is it fair to say you followed her on Facebook?
Yes.
Okay. What about Instagram?
No, I don't think so.
Just Facebook?
Yes.
Okay. Did you know if Jennifer had a son?
Yes.
Okay. Had you ever met him?
No.
Did Jennifer ever talk to you about issues she was having with her son?
No.
Did she ever tell you about a friend of her son's?
Yes.
Okay. And tell me what she told you about that friend.
It was his friend, and then he went away. He died.
Okay. Went away or died? What did she tell you?
Yeah, I believe he killed himself.
Okay. That's what Jennifer told you?
Yes.
Did you come to learn later on that that wasn't true?
Yes.
Now, I want to direct your attention specifically to the days around November the 30th of 2021. That's the day of the Oxford High School shooting. Okay, do you recall that event?
Yes.
Okay. Is it fair to say that from the time period that Jennifer moved back to Michigan up until November the 30th, 2021, you two would communicate on a regular basis with each other?
Yes.
Okay. In what method would you communicate? Would that be in person, text message, messaging app, or all three?
All three.
Okay. Did you save any of those messages between Jennifer Crumbley and yourself?
No.
Now, the morning of November the 30th, 2021, do you recall receiving a message from Jennifer Crumbley?
Yes.
Tell me about that, please.
It was, I don't know how it started, the beginning of the messages, but it ended up that she had to go to a meeting at the school.
Jennifer, is she had to go to a meeting at
Yes.
school? Okay. And what happened? Tell me what happened next in the conversation.
It was that something with Ethan. And,
Her son?
Yes.
Okay.
And was worried he was going to do something dumb.
Who was worried?
Jennifer.
Jennifer's worried. Okay. And she sent you that message before she had gone to the school?
Yes.
Okay. Now, prior to that, prior to November the 30th of 2021, were you aware that the Crumbleys had gotten a handgun for their son?
Yes.
Okay. And do you own firearms yourself?
Yes.
Okay. So you're familiar with how to store firearms and how to use them?
Yes, sir.
How did you learn that the Crumbleys had obtained a handgun for their son?
I saw it on a Facebook post.
Okay. And what was your initial reaction to that?
It was, I was just surprised kind of they got it, but
Why were you
I
surprised?
don't know. Oh, just that it was the handgun they had purchased. And
Okay. So you knew that they had got him that handgun by the time that Jennifer messaged you on November the 30th that she was afraid her son was going to do something.
yes.
Okay. Now, when she sent you that message, November 30th, what was your response?
I asked where the firearm was.
And why did the firearm click in your head at that point?
That's with my background and everything. It's I know that would just be if something was going to occur, that would be produce just immediate irreparable damage compared to any other possible thing that.
Okay. That being the firearm?
Yes.
All right. Did Jennifer respond to you? Let's back up. I want to make sure we have the chronology correct. So November the 30th, 2021, that's a Tuesday. She indicated that she had to go to her son's school. Is that right?
Yes.
Okay, and she told you what she was afraid of?
Yes.
And what was that again?
That he was gonna do something dumb.
He isn't her son?
Yes, sir.
Okay, and then your next message or response to that was asking about the firearm?
Yes.
Okay. And what was Jennifer's response to that?
That it was in her vehicle.
Okay. And what did you think about that?
I said that wasn't a good place. It's not, it should not be there.
Okay. And do you recall what she said?
No.
Okay. Now, do you recall if this conversation was over the phone or was on a messaging app?
Messages.
Okay. Now, later that day, November the 30th, 2021, did you learn what had happened at the Oxford High School?
Yes.
Do you recall how you found out about that?
Through social media and the news.
Now, after that shooting, did you continue to communicate with Jennifer?
Yes.
Okay. Now, we have already introduced evidence through an expert in computer forensics about how messages are saved and if one person deletes and one person doesn't. You told us that you had deleted those messages with Jennifer?
Yes.
The Facebook messages?
Yes.
Yes? Okay. So, a search warrant was executed from Facebook itself and obtained some messages. And Your Honor, we have already introduced some of these messages through Edward Wogrowski. The people are going to seek to omit the remaining Facebook messages between Mr. Milosh and Jennifer Crumbley as a new exhibit. That's 426.
Exhibit 426.
Your Honor, I'd like to just review 426, but if it's the same as what was previously, or just the whole thing, that's fine. I just don't know, is there more than what you gave me before?
So, you should have all those, but with Mr. Wogrowski, we omitted 8 pages of that. I'm just seeking to put the whole thing.
What's the whole thing? I have not been provided that. This is the first time hearing that.
Okay.
I probably have no objection, but I need...
Okay, but when you say it's the whole thing, it's the whole communication between Mr. Milosh and the
The
defendant.
remaining communications that begins December the 1st, 2021. It's a PDF. It was printed. It'd be 77 pages long.
Okay.
And it has the remaining messages because, as we've already learned, when one person deletes but the other person is not able to, Facebook, the server, Facebook can retain them. So this is what's remained.
Okay, so how long is this exhibit?
It's 77 pages printed out. We're not going to go through all 77 pages, obviously,
Okay.
but I want to make sure that we have the whole thing.
I would just like the record to establish that when I was provided the proposed exhibits, I was provided 8 pages of them. Now, I understand that in discovery, through the 30 discovery books I have these.
Okay.
And likely as we go through, there won't be objections. However,
Okay, I'm going to ask him to show it to you.
okay,
Yes,
please,
sure.
yes. And Your
actually
Honor, I need
printed out
a,
extra copies. There you go.
Okay,
Your Honor, I'm going to need a moment. This is
okay,
77 minus 8 more pages than I was told.
okay. Well, yeah, I mean, there's a lot of discovery, and she didn't specifically know. Like this exhibit list doesn't say specifically.
Wait, Judge, throughout these...
Well, they gave me
Hang
those
on,
exhibits
I'd like
on
to
a
respond.
disc,
You'd
and
like to
it's 8
respond to
pages
this,
long.
Judge. I just want to respond to the judge.
Okay.
Throughout this
Yeah.
case, there's been different objections lodged by defense counsel. When we've displayed a portion of a Facebook thread or a portion of a chat, I don't want to have to go through that. I want to just give the entire exhibit to the jury.
Okay.
And counsel has had this for approximately 2 years.
Okay.
And
Correct. But,
Your Honor,
okay, I know what you're going to say.
The
Okay.
disc
You
they
have-
gave
you
me
have-
of the exhibits
There's
doesn't
mountains.
match.
There's mountains
Right.
of information. There's mountains of information. He's trying to admit a portion of the Facebook communication via Exhibit 426. You are not exactly clear what is in 426. You have the right to review that exhibit prior to it being admitted and determine whether you object or you do not object.
May I please have some time? I apologize.
Yes.
In
Yes.
all fairness, I understand there's mountains of discovery. I've read it all 2 years ago.
Yes, I know.
I was given actual copies of what the prosecution intended to use at trial, and it was 8 pages long. Today they're walking in with 77 pages. They actually gave me it on a hard drive.
That's a different exhibit, right?
Judge, these are
Okay,
these are
it
conversations
is,
from
but-
court client. They're
But
court
in
client
addition,
Okay, whoa. Someone might have to type this someday. Okay.
Yeah, I'm not really thrilled with how the judge is handling this on any particular level. At a bare minimum, she should be telling, like, okay, you need to shut up. I'll listen to you. Now you need to shut up. Now I'll listen to you. At a bare minimum. I don't like this. I don't like the way this is going. Yeah. Where's Judge Toll? We need Judge Toll. Yeah.
So there was another exhibit that was Facebook communication that might have been 8 pages long that was a different exhibit. Is that correct?
Correct.
Okay, what exhibit number is that?
That is
It's Exhibit 151.
151.
Okay. All right.
And,
So
Your Honor,
this is, yeah, I'm going to let you look at it.
I'm sorry, the point I'm making though is that
She already said yes. Oh my God, why are you still talking? The judge would be like, stop talking, I already rolled for you. That's what I want in my life. Stop talking, I've already rolled for you. Stop talking.
they identified the 8 pages, they gave me those 8 pages, and as new exhibits have been added onto the exhibit list, they have been providing them to me in advance of a witness getting on the stand. This is last minute craziness.
We know,
So
you've
I
said
apologize.
this.
I have to take the jury's time now to review something.
We know, we've
that
said
they
this.
handed me.
Judge, this is wholly inappropriate, especially in front of the jury.
Okay, wait.
I've already explained why
Okay,
we're doing
wait.
this.
You said specifically in Exhibit 151, there's an order about exchanging exhibits. What your exhibits are different than what discovery is.
We've already identified that in compliance with the court's scheduling order. We complied with discovery. This was turned over 2 years ago. And this is covered in the stipulation signed by counsel.
I didn't say that you didn't comply with discovery. If we put everything in discovery into evidence, we'd be sitting here for another 5 weeks, right?
Yes.
But what is provided in discovery is different than designating exhibits. You designated Exhibit 151 as Facebook messages from Jennifer Crumbley to Brian Meloche.
Yeah, the jury's here for all this enjoyable thing too.
So that's
The jury gets to hear all these.
There's
The
not,
jury gets to hear this entire argument, all these speaking objections and everything too. So that's fun too. The jury gets to hear this wine fest. That's fun. Yeah, apparently, okay. So here's what I understand about sidebar. Here's apparently my understanding. This may or may not be correct. Okay, so apparently they had to seat more jurors in the jury box than they're used to seeing, because of the case. I guess they have more alternates than they otherwise would have. So apparently the jury box is not big enough, and they had to add some extra chairs. And apparently, it was determined that if they were speaking at the desk like a sidebar, that the new jurors who are closest to the desk would be able to overhear it. So the only solution apparently was a sidebar in the hall, which they talked about doing day one. It's like, we can't do it to the desk, so if we're going to do a sidebar, we have to go out in the hall. So apparently, having given up at that, we've just decided to do what should be a sidebar in completely open court with the jury. That's apparently now we've decided what to do. We're just doing sidebars, but not. This is a thing that's apparently happening now, and great. Yeah.
a description of that exhibit, right? So in what way would she know exactly what that exhibit was comprised of?
If she wants more time, we have no objection to reviewing this.
Okay.
Your Honor, the answer is they gave me a hard drive with each exhibit on it.
Okay.
I had a hard time opening some of those exhibits, but what's on the hard drive they gave me is the 8 pages in Exhibit 151. They did not include 77 pages.
Okay.
If I ever become a judge, I swear to God, my courtroom will not run this way. People may not like me. They may not like me. They may not like my firm hand. But if I ever become a judge, I swear my courtroom will not run this way. I will be much closer to Judge Toll than whatever this is. You know, there will be order in my courtroom. I will make a decision. I'm not going to allow this constant arguing. I'll be like, I've made a ruling, sit down. And let the Court of Appeals deal with it. You know, my courtroom, you're my bitch. That's how I feel, you know? Yeah.
Did you designate which exhibit it was? Did you?
Yes. 151 is a portion of the Facebook thread.
I
We did this
know it is.
with exhibits through Edward Rogowski. That's why we admitted 423. We went through the whole
Okay, well,
process on the
I have a
record.
list of exhibits, and it doesn't say what that one is.
Again, I'm just trying to give full context, Judge. We've gone through this with multiple witnesses.
Okay.
This isn't a surprise. This evidence has been with defense. We have the witness who's the declarant, and then her client is the other.
Your Honor, this is a surprise.
Okay,
And so to say this is not a surprise, it is a surprise.
Okay, it's not-
And this is
Judge Toll didn't pass the buck. Judge Toll just made rulings. Judge Toll didn't do anything like passing the buck. She made a decision and then said, I made a decision. Eat me. Yeah.
a repeated
Okay, done.
pattern.
Okay, I get it. You guys are repeating yourselves, all right? All of this information has been provided, but there's a lot of information. If someone wants to admit an exhibit, they have an exhibit, and the other side gets to review what the exhibit is and decide whether they object or not. Ms. Smith has objected to almost no exhibits here. They've all mostly been admitted, right? But the defense has a right to review what the prosecutor wants to present as an exhibit. It's not that they didn't have, everybody's had everything. There are boxes and boxes of things. But she has a right to review the exhibit. And rather have you sit here, I'm gonna have
Yeah, she's explaining it to the jury now.
licorice,
That's what's happening.
donuts, and what else do we have back there? Cookies. I'm gonna let you do that for 10 minutes while she reviews the exhibit.
Okay, so now the jury gets cookies. Is that what happened? Hold on one second. I just got to double check my ears on that one. Just 1 second.
Licorice and donuts, and what else do we have back there? Cookies.
Yeah. All right. Thanks for sitting through this, members of the jury. You now get licorice and donuts and cookies. Okay.
I'm gonna let you do that for 10 minutes while she reviews the exhibit. Okay? All right.
All rise for the jury.
Your Honor, I can just review it.
Hold on.
That's fine.
Hold on. She hasn't received the exhibit. She can stay here.
She can stay here.
I think she can. She needs to show her the exhibit. Is that right?
Your Honor, the biggest fear I have though is that the microphone picks up, and I've been told multiple times that it picks up between myself and Mrs. Crumbley.
Yeah, my
So
husband
can we have it turned
continues
off?
to tell me that you can be heard. Can we turn off the camera and everything right now, just so they can?
Okay, kids. Well, after that shit show, we're on a 10-minute break while defense counsel takes the time to review this documents after all that sidebar, which was held in open court before the jury, and also the judge doesn't really have control over anything. It's a pain in the ass. So, yeah, great. There you go. Yeah, commands look like they're working to me. They're working just fine. Father Martin says this is a show trial. I disagree. That's a show trial within the sense that you mean it. I don't agree with that. But okay. Yeah. I think people use these terms too infrequently or too loosely. Like, people were saying that thing about Judge Toll, too, like yesterday. Oh, this is a show trial. Oh, it was in the bag and all the rest of it. I'm like, you know, that's not what I see. That's not what I see. You know, the judge makes any ruling for anyone. Oh, they favor the prosecution. Oh, they favor the defense. Oh, they're assisting the defense. Oh, they're assisting the prosecution. It's like, you as a judge, and then if they don't do, and if they do things, they get blamed, and if they don't do things, they get blamed. Why isn't the judge intervening? They favor the defense. Yeah, judges just can't win. That's basically the conclusion I've learned from watching you guys. Judges literally can't win. If they do things, if they don't do things, they can't win. Like, I can't believe this is, yeah, you guys is like complaining because this judge, I can't believe that they're letting this go on. And Judge Toll makes the decisions. I can't believe, you know, that's whatever. It's like, oh my God. Thank you for the 128,000 subscriber compliment. I do appreciate it. I do definitely prefer Judge Toll to this. I prefer a firmer hand. It's like, I prefer a firmer hand. I'm in control. I am the captain now. I am the captain now. I am a minor demigod. This is my sanctum. You will obey my will. You know, obviously that can go way too far. Obviously that can go too far in the extreme, but the overall sentiment is correct. You know, it's like, here's what's happening, and she just lets him go back and forth and back and forth. That's like, no, I'm not going to let you go back and forth. It's like, you get to speak, I'm going to make a decision. Yeah. Not all of us don't generalize. Cute. The judges and lawyers are both inexperienced. Well, these lawyers are not inexperienced, at least the defense is not. The defense was one of the lawyers related to the Nasser case, the Olympic abuser who abused all the children. So she's had experience. The judge, I don't think, is new. She just doesn't have big judge balls. Courtney Clenny, the parents were arrested? I didn't see that. What are the parents being charged with? What did the parents do in the OnlyFans stabbing murder? What accessory or something, maybe? Accessory charges, perhaps? Because they helped their daughter out to try to erase evidence or something like that, maybe? That'd be good. Tampering with evidence, accessory after the fact, something like that, maybe? Didn't specify the charges? Well, if I had to guess, obstruction of justice, tampering with evidence, possibly accessory after the fact. Those would be the kind of charges I might expect. Something to do with the boyfriend's computer? Yeah, they're going through the boyfriend's laptop. Tampering. That sounds right. Tampering. Yeah. Could be. Yeah, that sounds right. Computer crime? That too. Computer crime? If the feds want her for the Computer Fraud and Abuse Act, they'll tear them apart, man. Where they say tampering? No one said tampering. I said tampering. Because someone said they were arrested, and then said arrested for what? And then the next person said, I don't know. And I'm like, okay, here's what I think is likely. And then I started listing charges I think were likely. And then someone said something else. I'm like, oh, okay. So I said tampering because I was taking a guess in the dark. What would make sense for the parents to be charged with? Here are some things that would make sense. Tampering would make sense. Okay. So, yeah. And also the media reports may or may not be fully accurate. Am I not clear when I say these things? I thought I was clear when I said it the first time. Was I not clear when I said it the first time? I was like, oh, they're arrested. Oh, for what? What could it be? Here are some ideas. Was that not clear? Or are people just not hearing me? You said tampering, and I'm like, oh yeah, tampering would make sense. So you might say tampering. I'm like, oh yeah, tampering would make sense. Was that charge would make sense? Okay. Kale Burke, our mod, is now trying to gaslight us all in the mod chat by trying to convince us that the commands weren't working. Kale Burke is trying to retrocon reality right now in the mod chat. Lol. Am I mad at you? Sometimes. Sometimes I'm mad at you. Sometimes I'm mad at you because I don't say things, and then people say I said things, and I'm like, that's not what I said. Even as I just said it just now. It's amazing. You know? So I'm often wildly misunderstood. Even though usually I think I'm pretty clear. Sometimes it's because I'm not clear, but usually I'm clear and people are just not listening. It's frustrating sometimes. I'm mad and it's hard to follow my commentary. Is it? Really? It's hard to follow my commentary? Okay. I don't know about that. Man. The case, I think, was scheduled for 3 weeks, if memory serves correctly. But it looks like we're getting done faster than that. We're on day 5. Right now, it looks like the prosecution's going to be done today. It's Wednesday. So I would anticipate we're done next week, which is nice. If it ends in 2 weeks instead of 3, that'd be great. Yeah, 6 weeks? Maybe it was that. But it looks like we're going to be done faster than that. Unless the defense really has 5 weeks worth of witnesses, and how can they? I wouldn't let the defense have 5 weeks worth of witnesses. Then again, I would have put both sides on a clock long ago. It's like we need, you know, it's like also in like Kohberger. Like Kohberger, aren't they talking about like 8 weeks or 12 weeks or something for Kohberger? I'd be like, you have 5, both combined. You don't need 8 weeks or 12 weeks for Kohberger. That's ridiculous. It's not that complicated a case. It's like, you've got 5 weeks. Figure it out. If you came to me with Kohberger and it's like, I need 12 weeks, I'm like, no, you don't. It's not that complicated, man. Figure it out. 12 to 15 weeks? Yeah, that's ridiculous. I'd be like, how about 5? Figure it out. That's not enough time, Your Honor. Well, I don't care. Figure it out. Oh, that's not fair. Eat me. You know, you're going to have to really justify your ask on that one. You're going to have to really justify your ask. We're going to go through exactly what witnesses you plan to call, exactly what they need to say, and exactly how much time you think it's going to say. And then I'm going to start cutting. Cut, cut, cut. Cut, cut, cut. It's like if I made you, I could probably make you do Kohberger in a week if I really made you to. You know, just do faster. Stop wasting time. Stop wasting my time. Stop it. Stop wasting my time. It's one of those rules of meetings, and anyone who's been in meetings knows this is true. The meeting will last as long as the meeting is scheduled to last. It's sort of one of these truisms of meetings. If the meeting is scheduled to last an hour, it will last an hour. If the meeting is scheduled to last 5 minutes, it will last 5 minutes. This does not necessarily imply that everything wasn't covered in the 5 minutes, right? This meeting could have been an email. Exactly. You know what I'm talking about? Yeah, you do, right? So the meeting will take as long as the meeting takes. So if I schedule it for 3 hours, it will take 3 hours. Even though there's not 3 hours material, you will consume the time. So I was like, how about no? How about you can't have that much time? How about less? That's not fair. That's not fair, Judge Uncivil. That's not fair, Judge Uncivil. And I'd be like, wah, I don't care. Tell somebody else about it. 400 witnesses? You don't need 400 witnesses. Absolutely not. You can't have 400 witnesses. You can have 20. Figure it out. Thank goodness I'm not the judge. I'm just saying, man. Judges need to have control of their courtroom. I'm not doing really fundamentally anything different than Judge Ascarati did. By the way, I'm really not doing anything different than Judge Escarardi did, or other judges who understand the magic that is the chess clock. It's like, look, this is how long it's going to take. This is how much time you each get. Figure it out. Yeah, that is just a judge who's like, I'm in control of scheduling this thing. Here's how much time you have. Figure it out. Chess clock for life. Chess clock for life. Yeah. So you probably should be grateful if I am your judge. Because I'm like, let's just all I'm basically saying is get to the point and stop wasting my time. That's basically what I'm doing here. Get to the point, stop wasting my time. Stop it. For example, in this case, did we really need to hear from the 911 caller? Was that really super important? Would you be mad if me as the judge, I'm like, how about you don't get to call that witness? How about no? You can't call that, you can't have that witness, but we want to, Your Honor. No, you can't have that witness. No chess clock in a criminal trial? Bullshit. You can have chess clock in a criminal trial. Of course you can have chess clock in a criminal trial. Chess clock is best. You can have chess clock in a criminal trial. It's about scheduling. The judge gets control of their courtroom. You can have chess clock in a criminal trial. Bullshit. Yeah, bullshit. As long as it's anything reasonable, right? As long as it's anything reasonable, you can have a chess clock. A judge can put a limitation on how long the trial is going to take. Yeah, no problem. As long as it's anything approaching reasonable. The standard is abuse of discretion. The standard is abuse of discretion. So as long as it's anything approaching reasonable, the judge is going to win. You know? Yeah. McMorrin preschool abuse trial lasted 7 years. That's ridiculous. A 7-year trial? How is the jury expected to hear a trial that long? That doesn't make sense. A 7-year trial? That's absurd. There's no way that makes sense. No, there's no way that makes sense. We are not having a 7-year trial. I'm telling you that right now. I guarantee you. We're not even having a year-long trial, if I can avoid it. For us to have a year-long trial, it would have to be like the most complicated. It would have to be incredibly factually complicated. It would have to be some sort of like, I don't know. It would have to be, we really need to get into corkboard and 3x5 cards and string territory before we're talking about even a month-long trial. Kohberger is not that complicated. There's no way Kohberger's that complicated. You know? Yeah. The case was 7 years, not the trial itself. Oh, that sounds a lot better. The jury spent 2.5 months deliberating. Okay, fair enough. Yeah. The case is 7 years, not the trial. Okay, that's a lot more reasonable. 2.5 months of deliberation is a lot of deliberation, man. That's a long deliberation. That's a hell of a time. Kohberger's complicated? Is it really that complicated? Is it really? Well, that's why I'd be asking. Is it really that complicated? Really? Or are you just pretending it's that complicated? Is it really that complicated? I have questions. Do judges worry about getting it wrong? Depends on the judge. Some judges are very sensitive to it. Other judges are not. I think as a general proposition, judges are worried about being overturned on appeal, especially in criminal trials, because they don't really want to do it again. But some judges are more sensitive to it than others. The first of 2 trials with 2.5 years, that's insane. That's insane. Trials almost 3 years, that's insane. That's insane. 30 months of testimony, that's ridiculous. There's no way that that's required. Why am I not a judge? Well, I haven't been eligible long enough in Texas to run for judge, and in Virginia it was appointed, and I didn't have enough political clout. So that'd be why. You have to be a lawyer for 4 years, I think, before you're eligible to be a judge in Texas. So 3 more to go. And then I'm going to need money to run a campaign, so that's going to be fun. Do I need to do some attack ads or something? I don't know. Why do judges allow all that time? That's what I'm saying, man. Are there any YouTube judges? There's at least one judge who does broadcast his court on YouTube, yes. I'm sure there's more than that. There's a couple who do. There's a couple who stream their court on YouTube. There's a few. Yeah. It's definitely something that's going to be increasing with more social media. I think we'll see more judges broadcasting the court. Less Zoom, though. I really don't want to do Zoom if I don't have to. There was a time and a place when we didn't have Zoom, and people still did trials. So I'd really like to not do Zoom if I can. Yeah, get them here in person. Zoom is just painful. Especially the mic and audio, sometimes it's just painful. Incidentally, I want to donate in a cookie right now. The OnlyFans judge disrobed. That's true. You are correct. Why not televise? There's really nothing to see at the moment. They are televising, by the way. There's just nothing to see. Do you really want to watch the state seal of Michigan? We can view that if you really want to. Koberger's judge is only allowing streaming, and he's insisting on controlling all the cameras. So the court will control the cameras, and he will broadcast it, which I understand. I totally understand it, because we've seen what happens with some of these people and the videos. So the Koberger's judge like, no, the media can't stream it, but the court will film it, and the court will make it available, because I don't trust any of you guys. I appreciate that. Excuse me. It is not live. I assure you, I'm looking right at it. I'll let you know. Oh, it is live. I'm behind in time. Sorry. I wasn't streaming live. I was behind.
I just wanted to make sure you got your 10,000 steps today. You may be seated.
My bad.
We apologize. There is obviously a lot of documents and a lot of discovery in this case. All right. So, Mr. Milosh, you are still under oath. All right. Go ahead, prosecutor.
Thank you. Okay. So, sir, was it your common practice then to delete all messages between yourself and Jennifer?
So we're 2.5 minutes behind. No big deal.
Message was sent and received? Yes, sir. All right. So I'm going to show you what's been admitted as people's 426. You have a screen in front of you. Can you see that?
Yes, sir.
Okay. Now, this is information received from Facebook through a search warrant. If printed out, it'd be 77 pages. And we have a conversation participants between yourself and J.C. Crumbley. That's the defendant, Jennifer Crumbley, is that right? You have to say yes or no.
Yes.
Okay. The green, so we know, that's Jennifer Crumbley, correct?
Yes.
Okay, and then the blue would be you,
Yes.
Brian Milosh. Okay. Now I'm going to go through some of these with you.
I've been a lawyer for 15 years. I've just only been licensed in Texas for a year.
Page 16 here. And I guess first, these begin from what was recovered via search warrant from Facebook on December the 1st, 2021. And we have heard evidence already, so you're aware. See, it says UTC +0. Do you see that right there?
Yes.
Okay. So that actually means it's 5 hours earlier than the time on that text message, so you know. So the first message here would actually be November the 30th in the late evening hours. Thank you. Now, prior to this message here, did you have any other contact with Jennifer Crumbley from the time she expressed concern about her son to these messages coming to you?
Yes.
Okay, tell me about that, please.
That was,
Louder,
oh, I'm
please.
sorry. I apologize. It was after the shooting occurred, and it was that the gun was missing.
Which gun?
The 9mm. And I said to call 911.
You told her to call 911?
Yes, sir.
Okay, and you told before that you're a firefighter?
Yes.
So why was it important to you to tell her to call 911?
Just to allow the first responders, the police, or whatever, to identify that there's potential what's going on.
Okay.
If we're missing it and something's going on.
All right. Now, it's fair to say that the first message we have here that says 12/1/21 at 2:56 a.m. UTC 0, that's not the first message exchange between the two of you, correct?
Correct.
Okay. So just everything before that would have been deleted by both yourself and Jennifer Crumbley.
Correct.
All right. So again, I'm going to refer to a handful of these pages. And just so you know, this is everything that was recovered from Facebook. Okay, so this is page 16, exhibit 426.
Your Honor, I apologize. Does the court have Wi-Fi? Because the file's so large, my hotspot's not going fast enough, and they just emailed it over to me, and I can't open it on my computer. Do you know if there's a password or if there's a...
That is so not my department.
Yeah, mine either. Mine either, thanks. I appreciate it, though, that the court is helping. Do I go to OCS?
Judge, Ms. Nell sent it again with a reduced file size.
Oh, okay. I'll try that. Thank you. I'm sorry.
Thank you for subscribing on Twitch. We do appreciate everyone who supports us on Twitch. It really, really does help.
Blue here.
Just a friendly reminder to set yourself a reminder for a month from now so you
So this is
renew that
shortly
subscription. We do
before
appreciate it.
30th, 2021. And what did you write to her?
I can't even keep up. None are threatening. Facebook pulls those down instantly.
Okay, and that was in response to what?
Sending screenshots showing what was going on and everybody that was commenting through their stuff or regarding them.
Okay. That's page 16. I'm going to go to page 33. Jennifer Crumbley wrote what at just after midnight on December the 1st, 2021.
Agreed. I failed as a parent. I failed miserably.
And your response was?
You didn't do this.
Okay. Now, is it fair to say at that point in time your information was received regarding the shooting from Jennifer Crumbley?
At that point.
Did you know all the facts?
But I'm sorry.
Did you know all the facts?
No.
Okay. So throughout this text message or Facebook message conversation, there's messages from you expressing concern over Jennifer Crumbley, frustration by the fact that she's going to be charged, disbelief that she's going to be charged. Were those your opinions at that time?
Yes.
Okay. And I'm not asking you to agree or disagree. We just want the truth from you. So is that what you feel now?
No, not. I've received more info.
Okay. I'm going to move on now to page 38.
Your Honor, I am so sorry, but I cannot get the file they sent me to open, and I really need a minute to get this file open.
Okay, I personally can't help her back, but maybe.
Are you connected to your Wi-Fi?
No, it's not. That's the problem I'm having right now.
Don't you have it in hard copy or something? Because they let you review it for 20 minutes, didn't they? So you must have a copy because you reviewed it. I'm confused. How could you have reviewed it if you don't have a copy? I'm very confused. Oh my word.
Okay, the joint OC guest came on. I just need to be able to have this open. It says I'm connected now. Let me try this again. The first file was too big.
We're doing tech support in open court now. My frustration level's pretty high, by the way.
Okay, they sent a second file. I've got it. Thank you.
All right. Moving on.
All right, ready?
Sure.
Okay. This is page 38 of Exhibit 426. In the green, there are some screenshots sent, and then Jennifer wrote, seriously, question mark, exclamation mark, question mark, can't see my horses, question mark, exclamation mark, question mark, exclamation mark. And your response was what?
No one knows how to handle any of this.
Okay, and that was in regards to screenshots sent from Kara Pennick, is that right? You have to say yes or no.
Yes.
Okay. Now moving on to page 42.
Your Honor, I'd ask the prosecution to stop leading the witness. I haven't objected, but we've been doing a lot of leading.
Assisting.
Okay, that's fine. I'll make sure that I don't ask anything that suggests an answer.
Okay.
Okay. This is page 42. The top text bubble here in green. What did the defendant write?
Social media. We heard we may get charged too.
Okay, and your response?
I did hear that. That was mentioned on one of the news stations. I don't know how both of you could be charged. I can only assume they will charge James with the handgun not being secured.
Okay. And she wrote this December 1st, 2021, 11:10 p.m. UTC plus 0. So that is actually 5 hours sooner than that. So that would be in the evening hours of Wednesday, December the 1st, 2021. Is that right? Okay.
Yes.
All right. Also on page 42, there's a deleted message here. This is green. First tell us what this one says.
You unsent a message.
Okay, and you obviously weren't here when Mr. Robrowski testified to tell us what that means and what that red X means. But what is the message that was actually deleted here?
Is that the green I'm looking at?
Right here, yeah, the cursor.
It was. We had the string lock on it. It came within the case.
Okay. Now, you had talked to her via message on the morning of November the 30th, 2021, when she told you about having to go to the school, right?
Yes.
Okay. Prior to this message coming to you on Wednesday, December the 1st, 2021, in the evening hours, had she mentioned anything about a locking mechanism for the gun?
No.
Moving on to page 43. Okay. She wrote this December the 1st, 2021, 11:47 UTC 0. So roughly the same time as the deleted message we just referenced. What did she write?
The news articles are saying charging both parents.
Okay. In your response?
I heard that, but I can't imagine what they could possibly charge you with. Just remember, the news is not accurate. They notoriously fill in gaps where they have no info or report as fact. Report as fact.
That's true.
They get third hand.
Okay.
That's certainly
Again,
true.
Those were your feelings at the time?
Yes.
Okay. On page, well, what is the, finish this page here for us. So after they get info third hand, what were the responses in green?
It's coming from the prosecuting attorney. I need to retain a lawyer's stat.
Okay. And now we're in page 44. Again, this was Wednesday, December the 1st, 2021, the evening hours. That's the day after the shooting, correct?
Yes.
Okay. All right. Now we have already admitted this portion of your Facebook message thread. Again, a deleted message. Can you read it for us?
The unsent a message, the one below that.
Both. Well, both. You just give us the.
You unsent a message.
Okay. And then what did she write that was actually deleted?
Everything was secured, not loaded. Bullets stored away separately. OMG, OMG, OMG.
Okay. And again, this is the conversation, the first time I ever heard Jennifer Crumbley tell you anything about the firearm being secured.
Yes.
I'm going to move on to page 46. Here's 45 first. Another deleted message. What did Jennifer Crumbley write?
No, I'll never be okay. I lost my son, and he's a murderer, and I'll forever have to live with the guilt of that. I'm not even sure life is worth living anymore.
Okay, and that one was deleted. That is, now the timestamp is Thursday, December the 2nd, 2021.
Your Honor,
at 12.
I'm sorry, I object to the prosecutor saying this one was deleted. The message that was unsent is not sent, but the next message was received.
That's not the evidence, Judge. Edward Rogowski already testified to what this signifies.
Yeah, he said, and you can both correct me if I'm wrong, that if you unsend a message, it can be retrieved. And so the message below that is at the same time, 12:42:32.
Yes,
So
Judge.
the message below the you unsent a message is the retrieved message.
That's deleted. Edward Rogowski testified that with the red X, this return is signified. It was.
No, he
it was
testified.
deleted. Hang on, it was deleted, but retrieved from the extraction report, or from the server itself.
So you're saying that she deleted her message about how she lost her son?
I'm not saying that. That's what Mr. Rogowski said.
I'm just trying to understand. You're saying
Yeah, the expert computer guy.
Right.
okay.
So
Okay.
Testified.
That's the testimony. Anything.
You can unsend a message, but it can be retrieved, and those red dots are what note something that has been retrieved,
Yes.
right?
Yep.
That was deleted.
Yep. All right. Okay. I'll go to 46. I'm in some trouble here. All right. What did she say here on Thursday, December the 2nd, 2021, 12:51 p.m.?
My mom won't talk to me.
In your response?
You have more than you know. In our circle, no one is faulting you, and most feel really horrible for you.
And then, did you write something else?
Your mom won't.
Okay. And then the next page, what did she say?
She blames us.
I'm going to move on to page 49. Okay. tell us what she wrote here.
The top.
Yeah, go from the top.
And we will never be the same.
And your response?
Never, ever.
And she wrote what to that?
It's like mourning the death of my child.
Move on to page 50. Their discussion about obtaining an attorney.
Yes.
Okay, what did she write?
I know we're working on retaining one right now.
Okay. And then what does she say regarding the charges she might be facing?
They're saying involuntary manslaughter.
Okay, so that is Thursday, December the 2nd, 2021, 1:31 p.m. UTC plus 0. So that's actually the morning of Thursday, December the 2nd. All right, that's 50. Here's a deleted message. This was already admitted. Can you read us, please, what was deleted from Jennifer's phone?
We're on the run again. Helicopters, not sure where to message you.
We'll move on to page 53. And she wrote something to you right here at December the 2nd, 2021, 4:40 p.m. plus 0, so that's 11:40 a.m. on December the 2nd. What did she write to you?
We just bought new phones with old numbers to take care of all of this shit.
Okay. And the next message?
Clear your cache.
Okay. And then what was your response?
Good move.
What did you take that clear your cache to mean? What does that mean?
Just clear messages off, I guess.
Off of a device?
Yes.
Here's page 58. This was also previously admitted. Tell us.
That is definitely not what either Helen or Bruin said. Oh, Lord.
Read us this deleted message.
We're fucked.
And she said that to you Thursday, December the 2nd, 2021 at 2 p.m. Here's page 61. She indicated she retained an attorney.
Yes.
Okay, what did she write?
Thank you. We secured a lawyer.
Okay, that's December the 2nd, 2021. That is in the afternoon of Thursday, December the 2nd. Okay, and did you ask if they were going to be charged?
Yes.
Okay, and again, this is Thursday of that week, and what did she respond?
Yes, we'll be charged.
Now, this is page 64. There are some photographs here that she sent to you. Have you seen these photographs before?
Yes.
Okay, and do you recall what they depict?
Yes.
Tell us about that.
There's a gun and a person bleeding, and the thoughts won't stop, and I can't recall about
Okay.
one another.
But that you recall that?
Yes.
Okay, and what did you think of that?
Disturbing.
Okay, and she sent that to you, and then what did she say in the message right after she sent you that picture?
This is what they found, a non-threat.
Okay, she was referring. Who did you think she was referring to?
A school.
The school. Okay. And let's go through this conversation. What did you write?
And never even notified a liaison officer.
That was your question to her.
Yes, sir.
And what was her response?
I should reread? You really think I need to reread Heller and Bruin? Really? So your claim was that under Heller and Bruin, the Supreme Court of the United States, it's deemed unconstitutional to require a household to lock up firearms in any way. And you think I have the misunderstanding of Heller and Bruin? Really? Uh-huh.
Response.
But the paper they showed had all these things scratched out.
Okay. Now, did you know that she was actually sent the paper without things scratched out?
No.
Cross.
Thank you. I apologize. Is your last name Malash or Malosh?
Malash.
Malash. Okay. Good afternoon. I'm Shannon Smith. I represent Jennifer Crumbley. You and I have never met before today.
No, 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 Grant Gush, you can't do that. No, 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 that's not the right way to go. Could be, what's the historical precedent? That was not your claim. That was not your claim. We're not going to change the claim. The claim was I'll reread the claim because we're not changing the claim. Under Heller and Bruin, the Supreme Court, it is deemed unconstitutional to require a household to lock up firearms in any way. That was the claim. That was the claim I disagreed with. We're not going to change the claim.
Correct?
Correct.
And we have never even spoken on the phone, had any contact. Is that fair to say?
Correct.
Okay, I want to go back and explain to the jury, have you explain how you became involved in this case, okay? So after the shooting and after December 4th, it would be fair to say law enforcement got in touch with you to talk to you about your knowledge of anything related to Mrs. Crumbley or Ethan Crumbley, correct?
Yes.
Now, on that day and time, the first interview you did was with law enforcement. You met with somebody from the Oakland Sheriff's Department, correct?
Correct.
Now, the first time you met with them, you were interviewed for 1 hour and 42 minutes, correct?
Correct.
A long interview. Is that fair to say?
Yes.
And in February of 2022, you did a second interview with law enforcement that was about 1 hour long, correct?
Correct.
And then recently, so within the past couple months, okay, in December of 2000.
Read the ruling. I'll tell you what, I'll do you one better. How about this? This is your opportunity to prove me wrong. Okay, this is your opportunity to prove me wrong. All right, you have the cases. You have Heller. You have Heller. We'll go McDonald too. Heller, McDonald, or Bruin. Heller, McDonald, or Bruin, because you said Heller and Bruin, but I'll throw in McDonald just to give you an extra stab at this. So under Heller, Bruin, or McDonald for that matter, please cite me the relevant language in Heller, McDonald, or Bruin that says that. To get to the exact claim again. What was the exact claim? Because I want to quote this verbatim. Hold on. Where is the exact claim? Okay. Okay, no, that isn't it. I can't find the exact claim, which is annoying. I'll find it. Give me a second. Does anyone have it verbatim? Because I can't find it. Kestrel, if you type !bite me, that will help you out a lot on this one. can't find the exact claim. Yeah, so the verbatim claim was under Heller and Brunin, Scottus, is deemed unconstitutional to require a household to lock up a firearm in any way. That's right. That's the verbatim claim. All right, so under Heller and Bruin, Scottus, it is deemed unconstitutional to require a household to lock up a firearm in any way. Okay, so I'll give you a McDowell as well, just to give you one more. So cite to me the language in Heller, McDonald, or Bruin that says it's unconstitutional to require a household to lock up a firearm in any way. This is your opportunity to just show up Uncivil on a constitutional law issue. How exciting for you. Please cite me the exact language that does that. That'd be great. Thank you. Yeah, here we go.
2023, law enforcement did a third interview of you, correct?
Correct.
And that interview was almost 3 hours
Show up
long.
Uncivil.
Is that a yes?
Yes.
So you were interviewed once at the very beginning of the case, right after the shooting, correct?
Correct.
They're not going to be able to chat for a bit. That's okay. When they come back, they can show me up when they come back. Plenty of time to find their citation.
And recently, within the last couple of months, in December, you did this 3-hour interview.
Correct.
It's fair to say that throughout all 3 interviews, you tell law enforcement repeatedly that you have memory problems, correct?
Correct.
You do not have a good memory.
Correct.
I am not trying to be mean to you, but you have repeatedly said you don't have a good memory. Is that correct?
Correct.
Now, when you initially talked to law enforcement, they told you they would like you to write a statement, correct?
Yes.
And you did, in fact, write a statement. You typed one out, correct?
Yes.
Now, the date you typed one out, did you do this on the date you were first interviewed?
It was the morning after.
Okay, so the morning after, so it says you were interviewed Friday, December 10th, 2021, correct?
Correct.
So the statement that you actually typed out and wrote would have been done on December 11th of 21.
Yes.
Now, it's fair to say that in the statement, you gave law enforcement and police as much information as you could remember, right?
Yes.
And this time when you wrote your statement, this was way closer in time to the shooting than we are today, correct?
Correct.
Now, when you wrote your statement to police, a lot of the new information you're sharing was not in your original statement, correct?
Correct.
And you would agree with me that during the hours of interviews you've had with law enforcement, they have given you different pieces of information against Jennifer Crumbley, correct?
Correct.
And you have not had the opportunity to take all this new information you're getting against Jennifer Crumbley and talk to her about it, correct?
Correct.
The last time you talked to Jennifer Crumbley was December 4th of 2021. Is that a yes? It's fair to say that police, they have asked you the same questions over and over and over. Is that correct?
Yes.
And when they ask you the same questions over and over and over, you can tell sometimes they don't like the answers they're getting from you. You can tell that. Is that a yes?
Yes.
Okay. I need you to be loud.
Sorry.
Okay? Thank you.
Apologize.
So when you can tell they don't like the answers, you keep talking to them, correct?
Correct.
And when they've been interviewing you, they have started to talk to you about things like your job and your benefits, correct?
Correct.
And they have said things to you like, if you're helping Jennifer Crumbley, you could lose your job as a firefighter, correct?
Correct.
They have said things to you like, if you're helping Jennifer Crumbley, you're going to lose all the benefits, your pension, things like that, correct?
Correct.
It's fair to say that when you've talked to law enforcement, They have said things that make you feel like you're going to be in trouble because of your friendship with Jennifer Crumbley.
Correct.
So when you're up here on the stand today saying some of these things, we can agree they are brand new within the last few months.
Yeah, new that I've seen.
Okay, so largely what has influenced you to change what you say, what you said initially, is because police have talked to you and made you change your mind, correct?
It had to make me, from my original, that more information was needed.
Right, so my point is, you talked to them at first, back in December, right after the shooting happened, right?
Yes.
And then law enforcement met with you 2 more times and gave you information, right?
Yes.
And they told you that if you were helping Jennifer Crumbley, you would be in trouble.
Judge, objection. We're getting dangerously close to what defense counsel has sought to exclude, and I need to be able to redirect.
Yeah, let's be careful.
Well, the door's open.
Okay, let's be careful.
If counsel is going to lay the implication of a certain reason,
Well, you're asking whether law enforcement threatened him in order to get him to lie?
Yeah.
then the door is wide open for the people.
It might be.
Thank you, Judge.
Well,
I don't care if the door's open. That's fine. Mr.
Yeah, then I think we need to excuse the jury and have the
That's
defendant make a record.
No, Your Honor. We've already done that. That is not what needs to happen. But
This
if the
is
jury needs to be excused, that's
something
fine.
different.
you tell me. You tell me.
This is something different.
Well, there's allegations here that somehow this witness was intimidated by the police, and I would take that very seriously. So, if that's true, the jury should know that. So, that's a serious implication. So,
Judge, we can't allow counsel to say those line of questioning and prevent the people from having the witness give the whole story.
I'm not trying to keep the whole story. We can do that right now. They want to make a record that's not needed. I'll ask the questions. Okay. Mr.
No,
Maloche?
For proper purposes, we need a record made, Judge.
okay. All right, 10 minutes, guys. Maybe 5. I'm sorry, Mr.
Yeah, exactly, Michael. Heller decision says state law requiring dismantling or a trigger lock makes it impossible to use the weapon for self-defense. Says nothing about other forms of locks. Correct. So the original claim was false now, wasn't it? Yeah. Bite me. So who needs to reread the decision, him or me? Booyah.
Okay, everybody be seated. Actually, I think I might ask you to step into the hallway just for a minute, okay? We'll be right with you. I know it's not a very comfortable position to be in. We're doing our best. Okay. You may be seated.
Or what's about to happen, I'm not exactly sure, but it appears that this is going into some sort of area that has previously been excluded. All right, so it appears, based on context, that the defense moved to exclude something, and the prosecution's saying the door is open, and the judge says maybe. And so we're gonna have a discussion about this. Are you like opening the door? Are you sure you want to do this? So it's like, we got to be sure. So, and apparently this might speak to. Apparently, this would go potentially to the defendant's relationship with the witness, right? Potentially. It's like, were you motivated to lie because of the police? And maybe it goes into other reasons he's motivated to lie. So we're going to see how this hearing goes. The affair, maybe. We're going to see. We're all going to watch together. It's going to be fun.
Okay, so we had a motion to eliminate, when was that? November?
You can put the shit back in the horse if the judge lets you. Right? This is what we were talking about yesterday with Judge Toll. It's like, yeah, you can put the shit back in the horse, or it's up to the judge, right? Because if the door is opened, the judge can be like, yeah, the door's open, screw you. Or the judge can show you mercy and be like, yeah, the door's open, but no. Right? So the judge apparently is choosing the other option. Let's make sure you want to open the door. Okay, we're going to do that now.
March, when was it, 2022, and certain evidence was excluded, right?
Yes, Judge. Specifically, counsel sought to exclude all evidence of extramarital affair.
Okay, so,
Now,
yeah.
as an offer of proof, this witness, when asked, will testify that he didn't want that information out in the public domain. Now, I didn't ask him any of that information. Counsel is choosing to cross-examine him in a fashion which makes it appear that he's either been intimidated or willfully lied about statements made. He has a reason why certain statements have changed, Judge, and if counsel is going to be allowed to introduce this to the jury, we have to be allowed to rehabilitate him and show what actually happened. And if counsel does say the door is open, like she just said, first, I would like a record from Jennifer Crumbley herself that she acknowledges what this means. It is her decision in consultation with her attorney and is part of trial strategy.
Well, credibility of a witness is always at issue, and so is a motive of a witness. And I did exclude that evidence at your request, subject to later information that if indeed something having to do with their relationship lent itself to gross negligence or dereliction of duty, right? So I did grant that motion. So what is your position now? Because the jury can't be led to believe that they, waterboarded this guy to get him to talk or something, right?
Your Honor, my position is that if the court has found I've opened the door, the court has found I've opened the door, and I would like to proceed with questioning.
Oh, okay. Well, I'm gonna put that right back in your lap, right? Because you're asking me. I'm asking you.
Oh, I'm fine. I would like the door to be opened. I would like to be able to fully cross-examine this witness.
Okay, could you raise your right hand?
And Your Honor, I would object to the court asking Mrs. Crumbley about this. This is trial strategy that's left to the attorney.
I agree.
Judge, no. We need to have a full record for appellate purposes.
A record of what?
Go ahead and
Of voir dire of the defendant, just the way the Facebook message was introduced, that it is in consultation with her attorney. She understands what this means. She understands that counsel cannot use that prior ruling to her advantage. She understands that at her behalf, counsel has sought to exclude certain things and was successful. But now, counsel is adamantly requesting that ruling not be put in place, allowing the prosecution to cross-examine this witness, and when the defendant testifies as well, that's all out in front of the jury. So that's now fair game for when the defendant takes the stand, for which she's indicated she is going to do.
Okay, well, I guess I would say if the defendant takes the stand, it is fair game to the extent it's relevant.
Of course.
Right.
It's always to the extent it's relevant.
Right.
I can certainly envision a possibility how it might be.
Your Honor, I suppose the first thing I need is a ruling if I've opened the door and if this evidence is now relevant about the affair. Because I still think it's relevant that police threatened and made Mr. Maloche say things that were inaccurate, irrespective of the affair.
Okay, well, I don't know what happened. Did they interview him for 3 hours and then threaten to call his wife? I don't know. I don't know what happened.
No, they threatened him like I asked him about his job, his pension, losing those things.
That's counsel's characterization of something that is certainly not evidence. A question is not evidence, and that is certainly that we're going to explore now.
Well, I guess the prosecution is saying he initially had a motive, perhaps not to be completely truthful to the police because he didn't want his private relationship with the defendant revealed, which, I guess is understandable, but it sounds like maybe he wasn't completely open and honest with them as a result of that. But
now all prior, I didn't mean to interrupt, but now all prior consistent statements would be admissible under MRA 801. But first,
yeah, I'm not going to let you let the jury think that the police, threatened him or did something to make him say something he didn't mean just to avoid repercussions to him, whether it's employment-wise or personally.
That's fine. Your Honor, I have opened the door, and I want that door opened, and I want to fully examine this with this witness.
again, Wadier
I'm
from the
gonna
defendant.
ask her, okay, can you raise your right hand? Do you swear or affirm the testimony about to give is the truth so help you God?
I do.
Okay, you can put your hand down. Mrs. Crumbley, I wanna make sure, this has been kind of fast and furious here, right? Okay, so I wanna make sure you know what was going on. A year and a half ago, there were some motions that were filed about keeping some evidence out.
Correct.
I guess I would suggest that now that we're here 2 years later and there's more information about the case, I can't even tell you if I'd rule in the same way, knowing everything I know now. But that being said, I want to make sure you understand what your lawyer said, which is that I previously ruled that in and of itself, the fact that you were having a romantic relationship with this man, to me, was not evidence in and of itself.
Oh, you posted it on my Facebook. Ooh. All right. Should we go check the Facebook or should we keep watching? I don't know. We're in maximum spicy territory. I'll pull it up on the side while we're waiting. This will be fun.
Gross negligence or dereliction of duty. Therefore, I granted your attorney's motion to keep that information out of the trial. You understand that, right? Okay, but now this gentleman is being questioned about why he did or didn't make certain statements to the police. And your attorney...
Am I prepared to argue with what the Library of Congress said about Heller? No, I'm not. I asked you the citations in the decision. You said it was in Heller and McDonald. I want to know where it is in the decision. I'm not prepared to argue about what the Library of Congress said. I want to know where it's in the decision. You made a claim about the decision. It should be in the decision. Where is it? If you want to cite to the same thing the Library of Congress cited, that's up to you. But you have to show me where it's in the decision because that was your claim.
Has indicated in front of the jury that he might have some motives, or maybe he's been threatened by the police. And she has said to me that she wishes to pursue that line of questioning. And I want to make sure that you are supportive of that.
I trust her, so yes.
Okay, so you understand that then we're going to crumple my order up about that and throw it in the trash and go forward.
I do.
You understand that?
I do.
And you agree?
I guess, yes.
Okay. Do anything?
Judge, I think I should make a record so the defendant and perhaps counsel knows for sure. It's not just an affair with one man that was uncovered. There's web searches now. There's trips during work hours. There's when she was on actual work trips with other individuals. It's not just this person. It changes the tenor of the entire trial.
I don't think that that's appropriate. You're asking why this
Judge,
witness...
counsel has alleged that 2 investigators with 30 years of experience have committed basically a crime by intimidating a witness and lying to a witness, and that it requires a strong and accurate response. This changes the entire case, Judge. I can't let that comment go without being corrected.
Okay, well, I don't know any of this information. You're going to ask him, this witness, why he was protecting her, or why he didn't give full information to the police. We're not going to go off into Never Never Land and talk about trips or
trips with
him, though. Trips with him when she said she.
Apparently, this guy said, all right. They filed with the wrong. Goes, really, you're parsing words. Stop being disingenuous. Well, I'm a lawyer. I parsed him, and I said no. So I'm holding you to your claim. I'm not parsing words. I'm holding you to your claim. And you say, from the decision, the handgun ban and trigger lock requirement as applied to self-defense violates the Second Amendment. The district's total ban on gun possession in the home amounts to prohibition on entire class of arms Americans overwhelmingly choose for the lawful purpose of self-defense. I never said that a handgun ban was constitutional. I never said a trigger lock requirement was unconstitutional. Never made that claim. And then you make the claim safes and any other means have been deemed unconstitutional requirement. That's not what it says. That's not what it says. You quoted it yourself. Scalia would later say it would render free access to firearms for self-defense meaningless. That's not what the decision says. You quoted it. It says handgun ban and trigger lock requirement. It says nothing about anything else. You're wrong. It's okay. We can still be friends, not biggie. For me to call me out on YouTube, it's flat out wrong. You are. Is both disingenuous. No, it's not. And factually incorrect. No, it's not. As to what the meaning of Scalia wrote. I'm like literally reading the words. That's what Scalia wrote. The handgun ban and trigger lock requirement violates the Second Amendment. That's all he said. It's not disingenuous. It's not factually incorrect. You're wrong. You're wrong. You're overextending what he said. That's not what he said. And then as to the Library of Congress, whatever they had to say, while the court stated the right to keep and bear, this is what the Library of Congress said, while the court stated the right to keep and bear arms is subject to regulation, it found the DC gun ban on handgun possession violated the right because it prohibited an entire class of firearms favored for lawful purpose of self-defense in the home. Right. The handgun ban is illegal. It similarly found that the requirement that lawful arms be disassembled or bound by a trigger lock made it impossible for citizens to effectively use firearms for the core parts of self-defense and therefore violate the right. That's what they said. It did not say what you said. You were wrong. You made a claim that is not supported. I'm not parsing anything. I'm holding you to your claim. Your claim was wrong. You are wrong. Deal. Mic drop.
He was at work or using her son as an excuse to go somewhere. Trips with him in particular, Judge, that goes to the heart of gross negligence and failure to adhere to your parental duty. That is a part of the case that we moved past when the court issued the ruling.
About that.
Your Honor, lots of people have
It was
affairs
excluded.
and don't have children that shoot up a school. That's not true.
Again, counsel's now seemingly asking for the same ruling that she had achieved before.
I'm not. I don't care. I don't
Okay,
care.
I don't know what you're asking me to do because I haven't seen any of this evidence.
All right, Charles. Well, I'm banning you. It's been
I
fun.
granted the motion to eliminate.
Someone ban Charles, please. It's been fun.
I think some of these things were
Bye,
wrong.
Charles.
So when you say you're opening the door or whatever's happening, I want to be clear on how far the door is open because I also don't want to have this isn't a trial about she isn't charged with being immoral. Okay.
Of course, but she is charged with failure to adhere to her
I
parental
understand
duty.
that.
Your
I
Honor,
understand that.
It's going to come out that they had an affair, okay? It is not because of the affair that Mr. Maloche changed his statement. The first time Mr. Maloche was interviewed, he told them about the affair. The second time he was interviewed, he told them more about the affair. The third time he was interviewed, he told them even more about the affair. That's not his motive for changing his story. His motive for changing his story is because law enforcement put pressure on him and made him fear he'd lose his job.
All right.
That is completely inaccurate. Again,
Okay.
now we have to introduce witnesses.
Okay, I'm not addressing that right now. I'm addressing the now we're going to put in all this information about affairs and all kinds of things that she was spending time with him instead of her son. How far are we taking this? That's what I want to know.
I guess it depends on the questioning.
Okay, well.
Because if that's the record, and if that's the request, and if that is the defendant's wish, Judge, that's fine. But we are going to go through that door with the evidence that we have.
I'm not privy to the information. I don't know what happened. I don't know what the police reports say. I don't know what he said about his relationship with her. Right? I don't know that. But it's also, this is not a trial about her morality, so I want to make sure that we stick to the elements of the case and what you're required to prove, which is not that she's a bad person. That's
Judge,
not what we're here about.
Counsel has made it a trial now, and if law enforcement is appropriate or not. So
whether law enforcement was appropriate with Mr. Maloche or not has been made an issue.
yes.
But are we going to have another week of trial about how terrible Mrs. Crumbley is and?
This is the same argument as when the court brought up the pictures of the home. Nobody is arguing that they're terrible or dirty. We're arguing that they were grossly negligent in adhering to the parental duty.
I understand what you're
and that
arguing. That's
caused
why I want
death.
the evidence to be relevant as to that.
And Judge, we stuck to the very fine line that this court gave us in the ruling. Counsel's the one who has suggested, not just suggested, but actually alleged that two investigators intimidated and lied.
I understand that. That has definitely been raised and definitely should be evaluated. but I don't know what else you're asking to present.
Well, at a minimum, those investigators to testify regarding their statements. At a bare minimum, Judge, there's a number of items found off of the defendant's phone regarding the extramarital affair. The timing of that is important. And if you want us to stick to just what happened with Mr. Malash, that's fine. But there is a vast amount of evidence to draw upon, and I'm uncomfortable at this point with the defendant saying, I guess, maybe. I think she needs to speak with her attorney, and I think that record needs to be made clear.
We've already spoke about it, Your Honor. We've spoke about it extensively, and an affair is what an affair is, and if they want to sit here, it'll just make my case even stronger that all they are doing is punishing Mrs. Crumbley for the wrong things.
Okay, but
On the plus side, I get to change the title.
Because I don't know. Only
Is the firefighter captain himself married?
know what's going
Does anyone happen to know?
Does she know the extent of what's going to come out? I don't. So
She knows the extent of what happened, and what's going to come out is going to be the truth about what happened.
okay.
And at this point, her life is more important than her dignity in terms of she had an affair. Lots of people have affairs. I mean, that's the bottom line is, at the end of the day, doesn't mean you know your kid's a school shooter. It doesn't mean that you know your child is going to kill people.
There we go.
Well,
I've changed the title. I've changed the banner.
Duty to evaluate evidence, determine if it's relevant, and if its relevance is outweighed by its prejudice. So that's what I'm trying to do, sort of in the dark here.
Well, I believe that the affair is not the motive for Mr. Malash to say that the police put pressure on him the way they did to change his statement.
I understand you told me that. I don't know what's coming in beyond that. I don't know.
To be quite honest, they can bring in wheelbarrows and stuff to show the affair.
Ooh, wheelbarrows.
I mean,
That could get
if anything,
kinky.
it just goes
Anyone
to
down for
show they
wheelbarrows?
don't have
I didn't have that in my
Okay, well,
Rolodex.
They say that
If this winds up bringing in toys, I'm here for it, man. This could be fun.
To a Boy Scout meeting, she was with her lover. I don't know. That's an example. I don't know what's going to come out. So I'm. Okay, so you want me to bring the jury back in?
Yes.
As long as the defendant's satisfied, Judge.
Okay. I don't know what to say. I don't know what the evidence is going to show. But I'm not positive the jury hasn't already figured that out anyway. But.
This is fun. This is getting maximum spicy, guys. This is getting maximum spicy.
Yes?
All right.
I'm here for it. How did you touch each other? Did you use your firefighter pole?
All rise for the jury.
Was she a firehouse truck? I'm sorry, train. Well, either way.
All right, you may be seated.
Did the probies get to polish her?
Can you bring Mr. Malash back in?
Please walk this way, sir.
Mr. Malash, you are soldier oath, okay?
Yes.
Okay, go ahead.
Okay, thank you. Mr. Malash, we were talking about the 3 different times that you spoke to police,
Yeah.
correct?
Yeah.
It's fair that from the very beginning, the first time you talked to police, you told police that you and Mrs. Crumbley had had an extramarital affair, correct?
Correct.
You told police from the very beginning your relationship with Mrs. Crumbley involved a sexual relationship, correct? And so when you're in here testifying, it's fair to say that law enforcement talked to you about the affair right after the shooting. You told them all about it, right? I'm sorry.
Yes.
Judge, I think counsel needs to be specific. She's saying law enforcement and using general terms, and she needs to be specific when asking this witness question.
Well, there's a lot of different law enforcement, so it probably would be good to be specific.
The first detective that you had an interview with, you told him that you and Mrs. Crumbley had a sexual relationship.
Again, identify who she's speaking to.
Do you recall who was the first, which officer are you talking about?
Which one am I talking about?
Yeah, the first, you're asking him
Sure.
about the first one who interviewed him. I'm assuming you know who that is. There's lots of law enforcement.
I know, which is why I have the name. But
Okay. Do you remember who it was initially, Mr. Malash? Okay.
it appears to be Lieutenant Weir. Does that sound correct? Oh no, I'm sorry. You talked to Brian Joseph the first time, correct?
I don't know.
Okay. You have, okay, does it sound right if I said you spoke to Brian, to Joseph, I'm sorry, Brian, I'm saying your name. Okay, on 12/10, you went to the Oakland County Sheriff's Office, the Brandon Township substation, correct?
Correct.
You were interviewed at approximately 15:30 hours, so that would have been, what, 3:30 in the afternoon.
Correct.
Okay, and on that day, I'm having a difficult time telling which detective it was that did that interview. It was during that interview, though, that you gave them a copy of your Facebook Messenger thread, correct?
Correct.
You gave it to them on a thumb drive,
Yes.
and you specifically did turn that drive over to Sergeant Brian. Do you recall that?
I don't know.
The person, okay, if I said the person that you handed the thumb drive over to, was that the same person who did the interview with you?
Yes, they used the thumb drive on the computer.
Okay, I'm just checking. If the police report says you gave the thumb drive to Detective Joe Bryan, does that sound right?
I had no possession of the thumb drive. We were on a computer at the substation.
So he asked you for access to your messenger.
Correct.
You gave him access,
Correct.
and Detective Joe Bryan was the one who downloaded the messages.
I don't know the detective's name. I think Joe Bryan was a different interview.
Okay, so you don't know the name, but you know it was a detective at the substation from the Oakland Sheriff's Department.
Correct.
Okay. And on the report, I also see source Lieutenant Weir. I'm just having a hard time identifying which police officer it was. You're sure it was a police officer or a detective that you met with, correct?
Yes.
And you're aware that that interview was video recorded, correct?
At the substation.
Yes.
I was not aware.
And it was the interview that took place that was a little bit less than 2 hours.
Okay.
Okay, the day after that interview is when you were...
I understand it's cross-examination, but counsel can't just make a statement with the word correct at the end and then the witness clearly not understand and then just move on as if that's the truth.
Okay,
We have to be
yes,
specific.
Give him a second to think about it and answer the question.
Okay, and I'm sorry, I don't remember my last question. I think I was just establishing a time frame. You did the interview on Friday, December 10th, 2021.
That was the first time.
Is that true?
Correct. Yes.
Okay, and that was 1 week after the last time you had contact with Jennifer Crumbley.
Yes.
The first time when you spoke with the officer at the substation, you disclosed to them that you had knowledge about Jennifer Crumbley.
Yes.
And you said that you told them right away that you had had a sexual relationship with her.
Yes.
And the fact that you and Jennifer Crumbley had a sexual relationship is certainly something you did not want to be public, correct?
Correct.
You talked to police again, we talked about in February for an hour. Was that also at a substation?
The the second interview?
Yes.
No, ma'am, that was at a building over here, part of the county complex.
So you met them at the county complex and you had the second interview, which was just under an hour long.
Correct.
When you had that second interview, now that was in February of 2022, you told them again, you confirmed for them again, as much as you probably didn't want to, I had a sexual relationship with Jennifer Crumbley.
Correct.
In the third interview, back in December, just a couple months ago, they asked you again for more information and you told them again you had a sexual relationship with Jennifer Crumbley.
Correct.
Now, the prosecution may ask you a lot of questions.
Objection in the form of the question doesn't matter, but I ask him now, Judge.
I haven't even asked my question.
Okay, what's the question?
My question is, when you talked to law enforcement and you changed,
Again, I'm sorry,
Okay.
Specifics matter, okay? So if counsel is going to request this kind of question from the witness, she has to be
I
specific.
can't even get my question out.
Okay, well, he needs to know because there were 3 different times, so that would help him too.
Thank you, Judge.
Okay. Over the course of the investigation, you testified earlier that your answers to certain questions have changed. Correct?
Yes, I've added.
You've added. Okay. But one thing you have not changed, it's not the statements about your sexual relationship with Jennifer Crumbley. You've always said you had a sexual relationship.
How many times can he ask the word sexual now? Do we need to keep a sexual counter?
More details about where you had sex and other details about those experiences, correct?
Correct.
Now, when I was asking you if you felt like you were threatened in any way, that had to do with feeling threatened that your job was at issue or that your benefits could be lost,
Judge, I'm going to
correct?
object again. Form of the question, she needs to be specific. She's going to ask something like threats. That needs to be specific.
Okay, then I'll go to the third interview. I'm sorry.
Yeah,
In
be specific.
Okay, I'm going to be very specific. In the third interview, when you talked to them in December, they specifically said to you, talked to you about your job employment as a firefighter, correct?
Correct.
They specifically talked to you about the details of your benefits, including your pension, correct?
Correct.
They made you feel like if you didn't give answers they wanted.
Objection in the form of the question, they made you feel. How could he possibly testify to what somebody else's intent was? That would be speculation.
It'd be speculation.
I'll ask how he felt.
Okay.
When you were in that third interview, you were scared at the thought of losing your job or benefits.
No, I was not.
You do not want to lose your job or benefits.
No, I don't.
And when you were in that conversation with them, it was during that third interview that they asked you the same questions you had been asked many times before, correct?
Correct.
And they were saying very negative things about Jennifer Crumbley to you during that third interview.
Judge, specific.
Yeah.
Objection in the form of the question.
Yeah. Negative like what?
They told you that they had evidence of Jennifer lying about things, correct?
Correct.
They gave you the impression that you didn't know everything about Jennifer Crumbley.
And speculation, Judge, they gave
I'm
you
asking
the
his
impression. Hang on, I'm not
impression.
done. They gave you the impression. If she wants to cross-examine him on statements, she can, but she can't make a broad statement about what their intent was. That's speculation.
Well, their intent is speculation, but if you have specific examples of things that were said potentially by the police to this witness, you can ask the witness that.
Okay. Specifically, the officer talked to you about ranks within the fire department, correct?
Correct.
They talked to you about seniorities, correct?
Correct.
They talked to you about all the training you had to go through to take each position and the seniority levels at the fire department.
Correct.
You explained to them how you got to each position at the fire department, correct?
Correct.
The officer explained to you that it's important that all the cards are on the table, correct?
Correct.
And then the officer begins to talk to you and reassured you you're not in any trouble. Is that a true statement?
Correct.
And they begin to tell you things. That officer tells you he's not trying to be threatening to you, but he wants to put the cards on the table, correct?
What page are we talking about?
It's
here?
at 18 minutes and 57 seconds in the third interview. Do you recall that?
You could just play the interview.
And when he told you that the cards should be on the table, I'm asking your impression.
Just play the tape.
Took that to mean
Play that beautiful beam
that
footage.
Your job and your benefits could be on the line if you said anything.
Just play the
favorable to
footage.
Jennifer
Just play it.
Crumbley.
Objection. He just answered that he wasn't threatened. He just was asked that question and said, no, I wasn't threatened.
Okay, was there a specific threat made to you?
No, ma'am.
Was there any kind of veiled threat? Did you take anything as a veiled threat?
Yes, just that the information that's now out regarding my relationship was going to be out publicly.
Okay.
Okay, so there were veiled threats made against you.
Yeah, hold on.
I'm just clarifying. That was
What does veiled threats
Well,
mean?
I asked if there were any.
I know, Judge, and that's fine. The court's entitled to ask whatever the court
Okay,
likes.
I asked if there were any veiled threats, so that was his invitation to say, yes, they said that they would call my boss, or they said that they would, make sure everyone in my union knew, whatever it is.
Those are all great questions to ask, which I will.
All right.
okay. When you were
It is a little weird the judge keep asking questions directly. This judge has been way more active on that.
2 hours and 45 minutes. It's fair to say you discussed far more than in the first and second interview.
Did he just object to the judge's question? Strictly speaking, no. He didn't object to the judge's question. He just asked to basically the exact same question being made by the defense lawyer because it was improper. And then she's like, and the judge is like, well, I just asked the same thing. And then he's like, well, the judge can ask whatever. He says, well, you can ask whatever you want. You're the judge. But when she does it, it's wrong. I liked it. It was fun. It's good.
With police.
Correct.
And when you were interviewed the first and second time with police, when it was closer to the shooting, you would agree with me that you were truthful in those interviews.
Yes.
And during those first and second interviews, you also, in between those two, wrote a statement that you typed out.
Yes.
Okay, so some of the information that you're saying now is only from, and I'll go through specifically what I mean. So when you were interviewed in those first and second interviews, you never said that you thought there was something wrong with Ethan or that he was disturbed, correct?
Correct.
And today when you're on the stand, you're saying you believe he was disturbed or there was something wrong. Fair to say?
Yes.
And in part, the reason you have changed your opinion is from information the police told you when they did those interviews with you, correct?
That and through the media and everything else, additional information I've gained around the situation of people.
So you got additional information from the police, which you don't know whether it's true or not, correct?
Correct.
And you would think the police are being truthful with you when they're telling you information,
Yes.
okay? And if they're not being truthful with you, you're believing what they're saying anyway.
Yes.
And you would agree with me, because you just said you also saw a lot of media reports about various things in the case.
Correct.
Now, the media reports in the case have different information than things you initially thought or saw, correct?
Correct.
So when you've seen the media reports and you have a police officer telling you that the evidence you didn't know, it has made you second guess what you knew back right after the shooting, correct?
It didn't make me second guess. It just some of it, because of timestamps, allows me to recall stuff better.
Well, would you agree with me, and I know you said, you testified you have some memory issues.
Judge, I'd like the
That-
witness to answer the question. He wasn't done answering the question.
I thought he was, I'm sorry. I interrupted you, I'm sorry.
I don't.
You said there were timestamps.
Yeah, when it helps if someone enlightens me, like if we go through messages, then I can actually I remember things. I can remember things. If you request specific information, I can give it. If someone just asks for something, I'll put out information, not knowing what they're looking for. The more specific something gets, the more accurately I can answer the question or more appropriately? I'm sorry.
Oh, I'm sorry.
I'm sorry if I'm not wording that correctly.
No, you're totally fine. I'm going to put your messages up on the screen.
Oh.
Can you please turn this on?
That's all right.
It's on. Can you please switch it over?
All right.
Are we going to beautiful bean footage? Is that what we're doing now?
I have to get this. Is the screen on up there?
Don't have affairs. Affairs are bad. Don't cheat. Just don't cheat. That's always good.
You and I would agree that when you sent these messages back in November and December of 2021, when these messages were sent, at that point you thought differently about the case than you do now.
Correct.
But the information you had at the time was information that you had personal knowledge about because you had just talked to Jennifer Crumbley and had just exchanged all these messages, correct?
Correct.
You would also agree with me that when somebody in the courtroom shows you one message without the context around it, sometimes it's difficult to remember all of what you were talking
Actually,
about,
cheating is
correct?
illegal, and actually, cheating is technically illegal in many jurisdictions. Strictly speaking, adultery is still on the books. It's not prosecuted, but it is a crime in many states technically. So yeah, yeah, it is illegal.
It can be.
So for example, the prosecution asked you about this message, okay, on page 53. And I'm going to go up.
It's also illegal specifically in Michigan. It's a violation of section 750.30. Adultery is still illegal in the great state of Michigan. So yes, it was a crime too.
A little bit, and then we're going to go through it to see if the answer might be different. When you testified to the prosecutor, you recall testifying that Jennifer Crumbley, you believe, told you to delete all your messages, correct? And I'm going to go down. I'm so sorry.
I was just referring to what I read.
Okay, so 53, they just put up this text that says, clear your cache, I don't know, how do you say that?
Cash.
Okay, they didn't show you the messages before it or after it, correct?
Correct.
Okay, so let's go up a little bit before it, okay? Prior to that conversation, so if we just go a little bit up in the messages, okay? Jennifer Crumbley says, and this is specifically on page 53, and I'll leave it still, I apologize. Jennifer Crumbley said, can you see if James's account is deactivated? Correct?
Correct.
Now by that, you knew she was meaning his Facebook account.
Correct.
So you said, and it's up on the screen, I'll check. Your next message to her, about a minute later, was nope, still up, correct?
Correct.
Now, you would agree with me that you were responding to the message about is James's account still up? His Facebook account.
But yes.
So while you were having this text conversation, you went in and checked to see if you could see James's Facebook page.
Correct.
Now, Jennifer says to you, and I'm going to just keep going further down, we just bought new phones with old numbers to take care of this shit, correct?
Correct.
And at that time, it's when she's trying to delete all social media accounts. You are aware of that, correct?
Yes.
And Jennifer types to you, and this is the message the prosecution brought in, clear your cache, clear your cache, correct?
Correct.
It's cash.
And you said, good move, correct?
Correct.
She says after clear your, I'm going to say cache because I don't really know how you say it.
It's cash.
She says clear your cache, then check, okay? And you wrote cache cleared, it's still up, correct?
Okay, guys, we're going to be here for a little while with
I
Cachet.
clear your cache. She was saying close Facebook and restart
Objection,
it.
Judge, again, speculation.
Well, it does call for speculation.
I can ask him what he thought it meant. I'm sorry.
Okay.
Okay. When she's trying to find out if his account has been effectively deactivated, what did you do to see if the account had been deactivated?
What it says, I cleared my cache. It means that when Facebook cleared the cache, which keeps, I don't know the computer terminology, but it tracks stuff or whatever. So it kind of would make it refresh. So I would get a fresh view.
So you wanted to refresh it to get a fresh view to see if the open account was then closed.
Correct.
So this is not about deleting messages. This is about checking the status of a Facebook account.
Objection, speculation.
I'm asking him if he
Well,
perceived
ask
it to be.
him. Well, ask him.
Did you believe this message exchange was to find out if James's Facebook was closed?
Yes, that's what it looks like right now.
Okay, and then the conversation keeps going. Jennifer Crumbley says he can't get into it and we not deactive or hot deactive. Do you see that?
Yes.
And Jennifer writes WTF. Do you see that?
Yes.
And then you wrote, whatever you did, the second attempt to deactivate your account worked. Do you remember that?
Yes.
Okay, so looking at this now, then Jennifer says, so it's gone. And she says his, to specifically ask you, his Facebook account now is gone, correct?
Correct.
And you say, no, it's still up. Then you say his page is gone, right?
Correct.
Okay, so when we look at more context around that message, clear your cache, do you believe that the intent was to have you refresh to figure out if the Facebook account was active and had become deactivated?
Yes.
Thank you. All right. I am going to go through with you messages that were exchanged between yourself and Jennifer Crumbley back in November and December of last year, okay? They've been admitted and the prosecutor asked you about a few of the messages, okay? I will put the messages up on the screen, and if you need more context around what I'm showing you, I need you to tell me, okay? And I'm going to apologize in advance. Some of these are gonna go out of order. I'm gonna go in order of the messages, okay?
Okay.
So if my questions bounce around, it's because I just prepared them in a few minutes, okay? All right, so let's go to page 7, okay? Okay, and this is, okay, so on page number 7, after talking about, Jennifer's asking you, and I'm going to have it right on the screen, is my Facebook page still showing? I deactivated it, and you said you'll check, right?
Yes.
Okay, you told Jennifer you'll have plenty of threats, correct?
Correct.
And you told her at that point, I can still see your page, James's also, right?
Correct.
Okay, going down further, okay, so I'm going to go to page 8 of this text thread, and you can tell me if I'm going too fast. Jennifer sent you screenshots, okay, and I see 1, 2, 3 screenshots. Those were threatening messages that she had received, correct?
It appears that way. I can't see well.
And you told her right after that, that won't stop, and suggested to her, do not respond, correct? Is that
Correct.
right? Okay, now, there is pages 8 through, after page 8, okay, there's a number of screenshots, okay, that you begin sending on page 11, okay? And so on page 11, you send 1, 2, 3 shots. Those are threats you found on her Facebook to make her aware of those, correct?
Correct.
Okay, so then we go on to page 12. There's 3 more screenshots you sent to Jennifer showing her 3 more threats.
Correct.
Then going down, okay, and I think the jury is getting this, page 13, 14, 15, and 16 all contain more individual threats against Jennifer, correct?
Correct.
And it's fair to say at that point, you knew people were threatening her and her husband.
Yes.
On page 16, you say, I can't...
Hold on, objection. If you can't even see them on the screen, how is this witness able to say correct to her affirmative question, this is a threat? The witness needs to say whether or not, one, he can read it. If he can't read it, does he remember it independently? Because that's important to know.
Your Honor, if I knew this was going
And
to
even
be...
can counsel read it?
Okay, yeah, ask the question, and, yeah, ask him the question.
Okay, my question is, those messages that you provided to Jennifer were to show Jennifer specific threats that you could see on her Facebook page, correct?
I would say that what was going on, bad things being said, anything like that along those lines. There were a lot of people saying horrible things.
So some of them may not be a specific threat, but it's horrible things, correct?
Correct.
And overall, the things you are sending to Jennifer Crumbley, you, in your mind, want her to stay safe, correct?
Correct.
In the moment when you're sending her these texts, you are worried about her safety.
Making her aware of what's going on
Okay.
in the community.
And
Or on Facebook.
there was so much bad stuff, so many bad messages and threats and whatever else that you said to her,
Objection
I
on the form of
can't.
the question, so much bad stuff, threats, whatever else.
Yeah, ask,
Unless he has personal knowledge, that's no problem.
yeah,
Well,
ask
we
him the
just had him
question.
testify about the personal knowledge, so
Okay, so you saw there's negative things in the press, there's negative texts, there's negative Facebook posts, and you're sending some of them to her.
Yes.
okay. And it got to the point where you told Jennifer you couldn't keep up.
Yes.
There were that many.
Yes.
And again, on page 17, and I'm not going to go through each one, but on 17 through 27, okay? So over the next 10 pages of screenshots, you're still sending, I called them bad messages, which is
Judge,
vague.
objection, she can't refer to them as anything.
If you know, what are they? if
What
you
are
know?
these?
What are they, if you know?
If there's screenshots I took off Facebook, it was things people were saying regarding them.
But unless he has specific recollection, Judge, he can't testify without personal knowledge. It's a basic rule.
During that time, were you sending her screenshots of anything else?
No.
Thank you. Now, when you and Jennifer were talking, and if you need more context, let me know. I'm going to ask you about some specific things, but I've got the whole thread up, okay? Jennifer says to you, and I'm on page 30 of the text, her reaction was, Ethan ruined his life, our lives, and multiple others. I don't even know how to absorb this, correct?
Correct.
That was a response she gave to you about her. That was a response she gave to you about her feelings, as far as you could tell.
Yes.
Now, going further down on page 31, she said to you, "I'm in panic business mode, and I need legal help stat." Correct?
Correct.
What was your impression? What is your belief? Panic business mode means.
I don't know. Looking at what I'm just trying to pick out, I don't understand what.
She goes on in her next text to talk about selling the horse.
Okay.
And in these texts, she ends up talking to you about what she's doing with her pets. Correct?
I don't see that. I can just see what talking to Kira about for the horse. I'm sorry, I don't.
No, that's okay. I don't want to cut you off, and I'm sorry I didn't mean to. My question is, as Jennifer's texting you, it's obvious, and tell me if it's not, that she's trying to take care of various business
Objection.
related to their house and work.
Speculation again.
if you know, what was she doing and telling you about this?
What I see right here is dealing with the horses. That's what I can see with this page up.
Okay, we'll get to some of the other things later then. Now, when she mentioned getting an attorney, on page 32, you specifically asked her to defend you two or Ethan too, correct?
Correct.
And her response to you on page 32 was Ethan.
Correct.
Further, on page 32, Jennifer wrote to you, then there's the fact that the system failed. They should have never blown it off and made it seem of no concern and gave him the option to go back to class, correct?
Correct.
That does not say, I chose for him to go back to class.
Correct.
Jennifer Crumbley says it could have been prevented.
Correct.
Jennifer texts you or messages you, the whole conversation was very nonchalant. Oh, here's a list of counselors, but we don't see him as a threat. And we just agreed because he, capital letters, has never done anything wrong, correct?
Correct.
And when this text came in, you believed she was talking about the counseling meeting that you knew she had had at the school.
Correct.
In her description in this text is that they were nonchalant.
Correct.
And she, you know Jennifer Crumbley, you've dealt with her before, correct?
Correct.
In your opinion, knowing Jennifer, did she seem upset with the school?
It appears, yes.
She also goes on page 33 to say, I failed as a parent, I failed miserably, correct?
Correct.
Knowing Jennifer, did you believe she felt horrible? You wrote back to her in response to that comment, you didn't do this, correct?
Correct.
And on page 35, I'm scrolling down further, she lets you know, I'm scared, correct?
Correct.
And you say to her, I bet you literally need to disappear once you are free to do so. Yes?
Yes.
Why were you suggesting that she needed to disappear?
Just because of the public, everybody knowing everything that's going on with their names and everything, you can't be in the public once that your name's out like that.
So not being in the public, you were suggesting to her, you need to disappear in terms of not have the public see where you are, things like that, correct?
Correct.
On page 36, Mrs. Crumbley is talking to you a little bit more and mentions to you, my son did this. I still can't even figure out where his brain snapped. Correct?
Correct.
That was what she said to you on December 1st, so the day after the shooting. Correct?
Correct.
And your response to her, when she says she doesn't know how his brain snapped, was, I do not know, right?
Right.
You had no idea what could have happened.
Correct.
You had no idea or reason to see personally that something like a shooting was going to happen, right?
Correct.
So when you were testifying earlier that you had concerns that day and thought a shooting might happen, that's a new opinion you have that's different from this day when you were messaging Jennifer.
That was, I wasn't ever thinking a shooting was going to take place. I was thinking more he would hurt himself.
So you never thought a shooting would take place at that time, after that time, or now?
Correct.
So if you were concerned about anything from any conversations with Jennifer, it was about him hurting himself.
Correct.
Jennifer goes on and she's talking to you further about her reaction to everything that happens. And on page 36, she tells you, I want to die. Is that fair?
The redirect on this should be pretty fire. Whenever the
And
prosecutor's
on
allowed to
36,
talk again,
You told her,
I'm looking forward to
"Be
this
careful
redirect. It should be
of
fun."
anything you type on Messenger or text. It will all be subpoenaed and kept track of. The FBI is involved. They can access anything and everything, correct?
Correct.
And on that day, you were informing Jennifer, just know everything you say, law enforcement can get.
Correct.
And you were sending that because that's what you believed.
Correct.
And this is an example of everything they could get, correct?
Correct.
And at no time did Jennifer say to you, delete certain messages or anything, correct?
Correct.
And she didn't say to you, oh God, I gotta go delete all these messages, right?
Correct.
In fact, she just keeps texting you through the next couple days through Facebook Messenger.
Correct.
Even after you gave her the advice, they're gonna get it all. Yes?
Yes.
I'm going down to 39. And at 9:25 a.m. on 12/1, Jennifer Crumbley's told you that he is being arraigned and tried as an adult. Watching it now. You would agree with me she's talking about her son at that point,
Yes.
the shooter.
Yes.
You told her you had just heard it and asked how she was doing.
Correct.
And her response at 9:26 was, I'm sick.
Correct.
And then I'm going down to page 40. I'm skipping a couple messages, but if you need me to go back, you can let me know. Trying to find a place to stay right now. Jennifer sent that to you at 9:47 in the morning. Yes?
Yes.
And you would agree with me that when she sent you this text and said trying to find a place to stay right now, you knew she could not go to her home.
Correct.
And you also would agree with me that this was at a time when there was lots of threats, as we've discussed.
Objection, again, specificity, and we've already talked about this.
There was negativity. There was lots of negativity, correct?
I think that's a determination for the jury to make. Looking at the evidence.
Now, on page 41, you say to Jennifer, I'm glad you're safely out of the area. Jen, I can't even imagine being in your shoes. Why did you say those things?
Going back to like all the messages and everything where something involving her family or son, something happened and I can't imagine me if she was like that, bro.
Now, going down, she's asking you if you've heard anything, any other rumors, correct?
Yes.
You're telling her, I haven't heard anything.
Correct.
And then she says to you on 12/1 at 11:10, we heard we may get charged too, correct?
Correct.
And your response at 11:12 was, that was mentioned on a news station. I don't know how both of you can be charged. I can only assume they will charge James with the handgun not being secured, correct?
Correct.
Now, at that point, there was a message that was unsent that said, we had the string lock on it, came with the case, correct?
Hold on, objection, unsent, it was deleted. We've
Right.
already had this.
Okay,
So,
go ahead.
okay, so the message she sent you that was deleted is we had the string lock on it, came with the case.
Correct.
Okay, so Jennifer's representing to you, we had the gun locked.
That's a message I'm seeing now. I don't know.
Okay,
I don't.
That's the message you're seeing now,
Correct.
and that's the message the prosecution is saying she unsent you.
Correct.
Objection, it's not the prosecution saying this,
Yes,
that's the evidence.
the expert who testified about
Thank you.
what happens to unsent messages.
Well, I don't believe that he would know what the expert said, but Mr. Keaston, his questioning said,
Okay, well, his objection was that you mischaracterized that. So.
okay, the message about we had the string lock on it, do you know what a string lock is?
There isn't a string lock, but I know what was being referenced to it. A
What?
cable lock was being referenced.
A cable lock?
Correct.
So the message to you does not say, oh my God, the gun was unlocked, right?
Correct.
Even if she unsent the message to you and you never got it, the message says, we had the string lock on
Yes,
it.
delete it again, it's mischaracterizing the evidence.
It's unsent.
Well, no, it was sent and deleted. They retrieved it
Yes,
through an
thank you,
extraction.
Okay, but I guess my point is the message that was retracted does not say, we left it unlocked. That's what I'm asking.
Edward, he can testify that what the messages are. I introduced the exhibit. Edward Wogorowski already testified to what this means. So
Okay.
I think that speaks for itself.
Okay. Well, I think she switched to a different question. You didn't get a message from her that saying that the gun was unlocked.
Correct.
On page 44, there's another message that appears to be deleted. Deleted or unsent. Which word would you prefer me use? Deleted?
It's not my
retracted?
word, Judge.
I'm asking you just so
Asking
we
the
can avoid
counsel.
us. Pick a word.
I don't want to be addressed by
Okay.
counsel.
Okay, well, ask the question. Okay.
I don't want to be addressed by counsel. Is that where we're at in this thing? We don't even want to talk to each
There's
other?
another message that indicates it was unsent on page 44.
It would have been a message that he received, right? So it would have been a message he received.
Okay, so the message was everything was secured, not loaded, bullets stored away.
I'm sorry. I just want to take a brief pause. I was very mean to my mod Kestrel earlier, and I just wanted to apologize now that I've had a moment to reflect upon it. I shouldn't have been mean. She is just trying to help. She's just trying to get me back on track. I was mean to my mod. I shouldn't have done that. I was wrong. So I just want to take a second to say that. Uncivil made a mistake. Uncivil's sorry. It happens. It doesn't make it okay, but, you know, we err. All right, let's go back to the adultery talk.
Separately. Oh my God, oh my God, oh my God. Correct?
Correct.
Jennifer did not send you any messages that says we were careless with that weapon.
Correct.
She did not send you any messages like, oh my God, we left it unlocked and left the bullets in it, correct?
Correct.
Your understanding of what Jennifer says is secured, not loaded, bullets stored away separately, correct?
Correct.
And she is saying, OMG, OMG, OMG. You agree with me, that means, oh my God, oh my God, oh my God.
Correct.
Jennifer goes on page 45 and says, there's an unsent message at 12:42, okay? And so the next message has the unsent message, and it reads,
Judge, I hate to keep doing this, but it's mischaracterizing the evidence.
Yeah, it was sent to him and he received it, and then it was later deleted.
I guess I'm not understanding this unsent thing. Okay, so there's a message Jennifer Crumbley deleted
But it was first sent,
that was first sent.
and then it was extracted.
So it's extracted, it was ultimately deleted. That message says, oh, no, I'll never be okay. I lost my son, and he's a murderer, and I'll forever have to live with the guilt of that, correct?
Correct.
And she says, I'm not even sure life is worth living anymore. Correct? Jennifer Crumbley, at this point, from knowing her and receiving these texts, feels from what you know of her as a person, you would believe she feels really, really, really awful.
Speculation.
Well, it doesn't stand for speculation.
I asked him from what he knows of her.
Still speculation.
Jennifer also texted you, messaged
I
you.
think the jury can draw conclusions from that.
I have nothing left to live for. B was it. And I take it to mean he was it. I have nothing to live for. He was it. Does that message make sense to you?
Yeah, yes.
What is your understanding or belief about it?
Assuming that was he was it, that's what she was looking for Ethan.
On page 48, so I'm going down a little bit further.
We were supposed to have a short day today. Somehow I feel that's that's not going to happen now.
You gave her a warning at the top of that page about anyone that goes to your house will have their pictures, license plates, and identity plastered all over social media. People have lost their minds and need to rein it in before they get into trouble, correct?
Correct.
And you also said he wasn't, I've met him. That message is accurately displayed, correct?
Correct.
Okay, to give it some context, above that, Jennifer wrote to you, Ethan wasn't a bad kid, Brian, on 47, correct?
Yes.
And when you say he wasn't, I've met him, that's because you've met Ethan, correct?
Correct.
And you knew about Ethan from talking to Jennifer.
Yes.
So earlier today when you testified, you've never met Ethan. You actually have met Ethan.
Oh, I met him. I don't remember ever testifying I had not met him.
Oh, I apologize. I thought you said you had not met him. I apologize then if I said it wrong.
I don't really know what the defense attorney's really doing here.
Continue on.
It's strange.
Say, I can't condone or justify what he did, but I do know that he wasn't a bad kid, correct?
Correct.
So, from what you know from Jennifer, prior to any of this, she had never complained to you that he was a bad kid. She had never complained to you that he had any kind of mental health issues or suspected mental health issues.
Correct.
Jennifer's position on page 49, she says we will never be the same, and then her next text is, it's like mourning the death of my child, correct?
Correct.
It's fair to say that Mrs. Crumbley expressed sadness in these messages to you about her feelings with her son, correct?
Correct.
She expressed sadness about what happened to the victims and their families, correct? And the whole...
Well, an objection to the characterization of this evidence, Judge. You can read what's on the text. You can't testify to what Jennifer Crumbley was trying to express to him. Just the words.
Did she ever state that? Did she ever state that in the text?
Just what I'm reading here is, reading what's here, I'm sorry.
So these texts speak for themselves.
Yep.
Exactly.
Okay, and I apologize that I have to go through these one by one.
You gotta do your job.
I didn't have these
Well,
before. I didn't know they were being used. Now that I know they're being used, they have important information this jury needs.
Okay.
Okay.
They're paying very close attention.
On page 49, Jennifer tells you, don't apologize, Ethan's life is over. I need to focus on saving ours. Staying out of jail and not going into a financial hole, correct?
Correct.
And then she says to you, I really need my giving phone back.
Correct.
Knowing Jennifer, having texted with her many times, she meant fucking phone, correct?
Objection, again, Judge, can't speculate.
Well, he doesn't know.
I don't know.
Okay. You respond to her, yes, you support her in this, yes, you really need to focus on you, capital letters. Nothing you do and no attorney is keeping him out of multiple life sentences. You need to get an attorney to defend yourself, correct?
Correct.
Then you say you don't know how or what they'll charge, but they will try.
Correct.
And she says she's working on retaining an attorney. Now, she mentions to you on the bottom of page 50, they're saying involuntary manslaughter, correct?
Correct.
This is on December 2nd at 1:30 in the afternoon. Or, you know what, I'm sorry, 1:30. Is that correct?
It's morning, isn't it? I believe that's at 5.
Oh, I'm sorry, you're right. So it's at 1:30 in the morning. Jennifer says they're saying involuntary manslaughter.
Yeah, the time is not correct. I'm sorry, the 1:31 p.m. is at UTC, right? So we're going back to so it's like 9 in the morning. I'm just trying to clarify so I don't lose
Yeah,
where I'm at. I'm sorry, I put my time on it.
I have to be honest, I don't remember how that
Okay.
was, the plus or minus, but ultimately, this text was sent to you before official charges were announced.
It appears so. I don't.
So the basis of knowledge that you're relying on is what you're hearing in media and what people are telling you, correct?
Correct.
It appears on page 51 that Jennifer deleted another message that she sent you and deleted that says, we're on the run again, helicopters, not sure where to, I'll message you, correct?
Correct.
Now, when Jennifer says to you, we're on the run, she also verbally told you, we're running away from the threats and the media.
Objection, I don't believe there's any evidence that they had any verbal conversations.
Yeah, I didn't hear him testify to that yet.
Well, let me back up and ask a different question.
Okay.
Did Jennifer say anything to you that they were on the run, running from police?
Objection, say, I mean, we have to be specific here.
Yeah, did you talk to her on the phone?
I don't recall.
Okay, so when she says helicopters, do you know what that means? And if you don't, that's okay.
Yeah, I know what helicopter is. I don't.
Do you know why she typed that to you?
No, I'm really not.
Okay, then that's okay. That's okay, thank you. On page 54, Jennifer says to you that she's deleting accounts and deactivating accounts. If she talks to you about that again, correct?
Yes.
Now, on page 55, so going further down, we're on December 2nd, later that morning. I'm going in order in terms of your testimony. Does that sound fair?
Yes.
Okay, so going down more, on page 55, we can agree that Jennifer told you she just got into her email and there's so many death threats and hate. I literally just want to die. That's what Jennifer says to you. It says on here at 12/2/21 at 5:23 p.m. UTC +0, correct?
Correct.
This is before the charges against Mrs. Crumbley were announced.
I believe so. I'm really having trouble with the dates. What day is this compared to shooting? I'm sorry. I'm getting a little
No,
trouble.
that's okay. The shooting was on November 30th.
30th. Okay.
Okay, and we're talking now
It's 2
about
days after.
we're talking now about December 2nd.
Okay.
And then-
2 days after.
Just to make sure you have the context, on December 3rd, that was the day the press conference was held and Jennifer Crumbley was charged. Okay, so does that help
Yeah.
keep it straight? Okay. So she tells you that she got in her email. Okay, then the next thing, she says on page 56, which is the next page, is that her texts are even worse. Correct?
Correct.
On 59 through 61, there are a variety of screenshots that we see here. Did you see those as I went through on page 57?
Yes, I don't know. I can't see what they are, but I see you showing me screenshots.
That was going to be my question, and if you don't know, just tell me. Do you have any recollection of what those were?
I do not.
On page 59 through 61, you send a variety more, it looks like screenshots. You don't remember what those specifically were, correct?
Correct.
Any messages that you were forwarding were negative towards Mrs. Crumbley. Is that fair?
I don't know what these are. I can't see them.
At that point in time, were you still seeing negativity on social media and in the public?
I don't recall.
On page 62, Jennifer says, I need people who know us as parents to be behind us more than ever, correct?
Correct.
She never said something to you like, I need you to lie for me, right?
Correct.
There's 3 more screenshots sent. Any idea about those?
No idea. Not without seeing them.
Okay, then on page 64, Mrs. Crumbley sends you some screenshots. Do you see those?
Yes.
Now, I do believe the next text after may refresh your memory on what those screenshots were. Jennifer Crumbley wrote, this is what they found, a non-threat. When you were testifying earlier, you testified to the prosecution that that was when Mrs. Crumbley sent you copies of those the math worksheets.
Correct.
You began asking questions about the school and said they fucked up badly, correct?
Correct.
And she tells you there was a paper they showed that had things scratched out.
Yes, I see.
Okay, and towards the bottom of the page, Jennifer Crumbley says, and this is on December 3rd at 12:17 UTC +0, no, counselor and dean were in the room. They have us counselors' names to call, but said they didn't see him as a threat and he could stay in school, which he wanted to do. His fucking backpack was with him. Why didn't they search it? That's the text you received from Jennifer Crumbley.
Correct.
At that point, and at no point, you didn't say anything to Jennifer like, this is your fault, correct?
Correct.
It was unfathomable that something so awful would happen.
Yeah.
On page 66, Jennifer continues to tell you different things by messages, and she says no officer was notified, and apparently there were threats and no one, not even us, notified, correct?
Correct.
And you said, I don't understand how the school was so nonchalant about this and prior threats, correct?
Correct.
You sent that text because your belief was there were prior threats that Mrs. Crumbley had never heard about.
I don't know. I just know what I'm writing here. I don't recall exactly.
Okay, fair enough. If Mrs. Crumbley and you had ever discussed prior threats she knew about, you would have said something to her like, you knew Ethan had made prior threats, correct?
Correct.
You don't say anything like that to Mrs. Crumbley at this point. Jennifer says, I don't know, but it failed my son and 4 other families, correct?
Correct.
And then she says at the end of that page on 66, yes, but my child is alive, and he was responsible for, in capital lives, the loss of lives.
Correct.
I'm sick. Correct?
Correct.
On page 67, so I'm just going down further, he told you his eyes not right on his mugshot. That's not, in capital letters, my son.
Correct.
Is that correct?
Correct.
You responded, I said the same thing. That does not, in capital letters, look like Ethan.
Correct.
Why did you say that?
I'm gonna say because it doesn't look like the pictures of Ethan I've seen.
Okay.
That's all I can say.
At that point, were you feeling shocked in any way?
I was shocked about the whole thing. I can't.
Now, on 68, you end up telling Jennifer, it's so sad, I'm so sorry, and thinking about you nonstop, correct?
Correct.
It's fair to say that you wrote that because you were so sad, you did feel so sorry, and you were thinking about her, and everyone, everything that was happening nonstop.
Yeah.
Jennifer responds about how she's doing when you ask her, are you even sleeping, correct?
Correct.
And she says no. You say, I figured, correct?
Correct.
Okay, I'm on page 69 now. She says, I haven't slept in 3 days, and I have been eating the same quesadilla for 3 days, correct?
Correct.
You told her you need food and sleep, but I'm sure it will take days before you can do either, correct?
Correct.
You said that because you could tell the person you knew felt really bad.
Correct.
Jennifer then says, I'll have plenty of time on jail, correct?
Correct.
You know Jennifer to be a sarcastic person, correct?
Correct.
You would agree with me, and if you don't, please let us know. That was a sarcastic remark on her part.
You can't agree with that, so it's just speculation.
Do you know?
I don't know. Look, reading this.
On this date, back on December 3rd, you wrote, your attorney will prevent that. I'm still very pissed off at the prosecutor and system for charging you two. They are doing it to appease the public. That's called a witch hunt, not justice, correct?
Correct.
And to that, Jennifer replied, I'd rather die than go to jail, correct?
Correct.
Not the first time throughout this thread she said she wants to die.
Correct.
As the text thread continues, on page 72, I'm going down, but again, if you need me to slow down, let me know. Although we're going slow. She said, you've helped us a ton, just being a friend and not judging has helped. Your remarks within those messages, not text, was I'm trying my best. That's what real friends do, correct?
Correct.
At that point in time, on December 3rd, 2021, you would characterize yourself as real friends with Jennifer Crumbley.
Correct.
And James Crumbley.
Correct.
Following that, there's discussion about horses on 72. Is that fair to say?
Yes.
Sarah sent me pics of the boys. You know she's talking about animals. on page 73, she indicates to you, yeah, we're painted out to be monsters, and I can't defend myself because we're fearing our lives. Correct?
Correct.
So on December 3rd, the day before the day charges are announced, Jennifer is saying that she's painted out to be a monster.
Correct.
You end up responding to her, and I have to ask, is this sometime in the afternoon?
Are we asking these messages right here?
Yeah, I'm asking, what's your memory of when these messages were?
Well, it shows almost 2 p.m., so I'd have to back that up 5 hours, right? I don't know how to do UTC. I know it's 5 hours, and I'm not sure how that does that.
So it
Because I
would,
put that at 9 in the morning.
okay,
I
well,
don't know.
it's sometime that day, and obviously the times, we can sort those out later.
Okay.
They're on the text, right?
Yeah.
On the messages. And you said you have more support than you think, but right now, anyone who publicly defends you and James gets exposed, crucified, and threatened. I've been defending you and explaining to anyone who contacts me privately, correct?
Correct.
You were defending her knowing that there was a lot in the media and things people were saying that are not true about Jennifer Crumbley.
Objection to the vagueness of the question, Judge.
Well, I think you kind of put words in his mouth.
There too.
I guess I'll ask you, why did you say that you felt like anyone who publicly defended her and James was exposed, crucified, and threatened? What did you mean by that?
That it was such a horrific incident that nobody can possibly stand up for anything that has to do with other than the loss of lives and anything. That's the only way you can say anything about that. You can't try doing anything in any other way about that.
So it's fair to say you certainly didn't want to make public statements that you were friends with Jennifer, correct?
Correct.
And at that point, Jennifer says, I know, thank you, I don't want anyone in danger, correct?
Correct.
And further down, I'm on page, let's see here, 74. This is at December 3rd, 2021 at 2:36 p.m. UTC plus 0, so we'll calculate that out later. At that time, she says, not yet, waiting on my lawyer, correct?
Correct.
Now, that was in response to your question, have they advised you of all charges? Have they issued warrants, right?
Correct.
So her response, not yet, waiting on my lawyer, that was the response she sent to you. And at that point, you wrote to her, follow his or her advice carefully. Do not fuck yourselves. Be careful. Jen and my thoughts are with you. Why were you telling her not to fuck herself?
Just to make sure she followed legal counsel advice.
And
Not to do anything else.
from all of the messages you had with her or any communications, Jennifer Crumbley never said to you, I don't plan to follow my lawyer's advice, correct?
Correct.
Jennifer Crumbley never said, I'm going to lie about things.
Correct.
After that, there's some exchanges on page 75, 76 about reaching out to her, talking about money with Kira. Do you recall those messages?
Yes.
So at that point, you were trying to assist her in selling the horses.
Correct.
And ultimately, this is towards the end of the messages, the end of your communication with Jennifer Crumbley, correct?
I believe so.
Okay. She gave you lawyer's number, and then there's a phone number. If we need to do any type of legal sale of the horses that Kira needs, I can't get into my house to get the papers, correct?
Correct.
You tell her I'll put it in my phone, meaning you'll put the lawyer's number in your phone. Is that right?
Correct.
So at that point, you did save the number for the lawyer in your telephone. Is that a fair statement?
I don't know.
Okay. You said you were going to do that at 4:13 and 35 seconds UTC plus 0 at whatever time that is, correct?
Correct.
You told her, I'll message her as soon as I get home. Do you want to call me? And she says to you, send me your number, correct?
Correct.
At that point, Jennifer did not have the, if you know, and if you don't know, you can let me know. Do you know why she was asking you for your phone number?
I don't.
The last message you got from Jennifer Crumbley was on December 3rd, 2021 at 5:57 and 25 seconds UTC plus 0. That was the last message you heard from Jennifer Crumbley.
Okay.
Is that correct?
I don't know. I can't see what. Yes.
Would it be fair to say that the last message you sent to her was this last message we see on the thread? Any chance that your neighbor can get the papers for the horses? I can sign them. Kira seems to really want those purchases.
Yes.
I have to ask you just a couple of quick questions about your relationship with Mrs. Crumbley. When you and Mrs. Crumbley spent time together, most of the time, what part of the day was it?
Morning.
Was it mornings of work days or weekends, if you know?
Work days.
Okay. And I am sorry to invade private details, but approximately, did you have a usual time that you would see each other?
Okay. All right, let's do this.
I don't recall normal time.
Okay. During those times, you're not aware of where Jennifer Crumbley's son would be?
School, I don't.
So it would be fair to say that times you and Jennifer Crumbley were together were when her son would have been school day.
Ask what they were doing together when they got together. Ask it. Ask what they were doing together. That'll be good.
Is correct?
Correct.
In terms of the extent of your relationship, were there many trips or overnights or things like that?
No.
That if it ever did happen, was very minimal, correct?
Correct.
And at the end of the day, despite the fact that you and Mrs. Crumbley may have had an affair, you never believed that Mrs. Crumbley didn't care about her son, correct?
Correct.
Her relationship with you was very separate from her relationship with her child.
Correct.
And the amount of time that she spent with you was very minimal compared to the amount of time you knew she.
I'm sorry. Did one of you in chat, Cammie, did you actually type she would actually ask something asinine like that? It's like, yeah, of course she would.
Be at home and with her son and doing other things.
That's speculation, unless he has a lot.
No, it's too good.
Yeah, that's
Too
he
good.
didn't say that, so.
Okay, I can ask a better question. Throughout the days, while you and Mrs. Crumbley would talk to one another, you would frequently tell each other what you were doing as the day went on, correct?
Yeah.
I guess overall, during a typical week in 2021, how many times would you say you would see Jennifer Crumbley in person?
Once, maybe. I don't know.
Once a week.
We're not,
I'm in 21.
so we're not talking every day or anything like that, correct?
Correct.
He was on the
I
milk
have no
run.
further questions.
Oh, good.
Why did you stop communicating with her?
As soon as I saw in the news that the warrants were issued and they were being apprehended but not
but not turning themselves in?
Correct.
Okay. So I just want to make sure that we're all clear. You're not accusing anyone in law enforcement of threatening you, are you?
No.
Okay. And in fact, when you interviewed with investigator Mike Thomas December of 2023, he actually referred to you as brother. Would that be right?
Correct.
And you guys left the interview with exchanging phone numbers, and you actually called him the
Your
next day.
Honor, I would ask the leading questions
Sustain.
staff.
I'm sorry. Wait a second. I'm sorry. I mean, he kind of said that earlier on cross, and I kind of ignored it at the time because she asked a question like, did you feel threatened? And he said no, and I kind of ignored it at the time. But now he says it again. The prosecutor asks, you didn't feel threatened by law enforcement, did you? No. So what was that all about? Wasn't that like the entire premise of the thing? I thought that was the entire premise of the thing. I'm so confused because I thought the issue was he did feel threatened, and he was being threatened about his pension and his job and stuff, and therefore the police were bad and corrupted him, and we might be able to do sort of by implication that the police are bad and corrupted other people too because of their pressure. And now he's like, no, I didn't feel corrupted by it. So I'm so confused. I don't understand the point. I don't understand why we're here. I don't understand what that was all for, right? Because the whole thing was, okay, I'm sorry. We have to talk about this for a second because I need a minute. All right. The whole thing was about the door opening, right? Because she's making allegations that the police said things, and that arguably opened the door to other reasons. Now, I'm not sure that it did personally. I'm not sure that it did open the door, but apparently we went right past that issue to, I don't care if the door is open, ask anything you want. So I'm not actually sure the door was open, but whatever. The defense lawyer didn't argue, no, the door isn't open. She's like, I don't care about the door, screw it. So we never got that argument. But wasn't the entire point of opening the door or obliterating the door or ignoring the door so I could talk about the corruption of the police and how they pressured this guy to change his statement, and by implication implying that the police did what was the entire point of this exchange?
He actually referred to you as brother. Would that be right?
Correct.
And you guys left the interview with exchanging phone numbers, and you actually called him the
Your
next day.
Honor, I would ask the leading questions.
But not turning themselves in?
Correct.
Okay. So I just want to make sure that we're all clear. You're not accusing anyone in law enforcement of threatening you, are you?
No.
Okay. And in fact, when you interviewed with investigator Mike Thomas December of 2023, he actually referred to you as brother. Would that be right?
Correct.
And you guys left the interview with exchanging phone numbers, and you actually called him the next
Your
day.
Honor, I would ask the leading questions staff.
Okay. So what was the tenor of that conversation? Was it an interrogation? Was his voice elevated like mine, or was he calm?
But if the point was to get in the text because we want to humanize her, we just didn't have to go through the thing in the first place, right? Because we made a motion. It was the defense's motion to limit, right? We don't want mention of the adultery. Okay. And the judge said yes. I mean, you could always change your mind, I guess, right? I mean, a motion to eliminate binds you both, but you could always be like, upon further reconsideration, I'd really like to do that, Your Honor. And so we didn't have to go through the premise. Also, apparently, the prosecutor has absolutely no problem opening the door. The prosecutor's not like, you said, the prosecutor isn't out here saying, you said motion to eliminate. We're not going to let you back off that position. You're bound for it forever. Blah. No, the prosecutor's over here like, yeah, we're cool. So she doesn't need the artifice of the allegation against the police to bring it in. She could just be like, how about that adultery? And apparently the prosecutor's like, yeah, that's cool with us. I'm so confused.
Went back and forth. It varied.
Okay. Did you feel like you were being yelled at?
At some points.
So at one point he asked you about your pension. I'm going to look at the transcript here. When he first introduced himself to you, he was talking about you, how long you've been a firefighter, and your answer was, here 21 and a half years. He said, okay. And I worked for Independence, and I was on call for 7 hours before here. And then Mr. Thomas said, pensioner, straight 401. She asked specifically if he was threatened that his pension would be revoked. I think it's important that the jury understands what that context was.
Your Honor, all I'm asking for is that I get a chance for recross, because if the prosecutor's going to pick tiny parts of this transcript and not the whole thing, that's a problem.
Hold on, yeah.
No, I don't have the transcript.
She has, okay.
Oh my
first
God, are
of
we going
all,
to do this again with the transcript and what I do or do not have? Are we doing this again?
She accused 2 veteran officers of threatening when this witness said, no, he wasn't threatened. And I think it's important for me to go through that.
Wait a second. What did she just say? I'm sorry. What did the defense lawyer just say? I think my brain just caught up in real time. Hold on. I got to go back.
It's important that the jury understands what that context was.
Your Honor, all I'm asking for is that I get a chance for recross, because if the prosecutor's going to pick tiny parts of this transcript and not the whole thing, that's a problem.
Hold on, yeah.
No, I don't have the transcript.
She has, okay, first of all, the allegation of picking tiny parts, she accused 2 veteran officers of threatening when this witness said, no, he wasn't threatened. And I think it's important for me to go through that transcript, that interview, to talk about the portion that she brought up.
First of all,
he can pick whatever questions he wants out of there. He doesn't have to, you know, he can ask whatever he wants about that. You don't have a transcript.
I don't.
She can make her own transcript. She's a retained attorney.
It's fine.
Okay, wait. You have.
I've seen the audio. I took my own notes from it.
You saw the audio. That's a neat trick.
So, okay.
You've seen the interview.
Yes.
Yeah.
Okay.
Your pensioner straight 401. You said pension. How much longer you got? 3.5. You got a COLA, cost of living out of it? Your response, yeah. What's your COLA? Oh, I don't know what it is now. I think it's, what's your multiplier? 2.8. Was he threatening to take your pension away?
No.
Okay. Did you ever feel like he was going to have your job taken from you?
No.
All right. You were asked.
Yeah, the jury's definitely hearing all
You
this.
were talked. Mr.
Yeah.
Thomas asked you about the importance for the truth. Now, as a veteran firefighter, are you surprised that law enforcement wanted to gather the truth?
No.
Okay. And in fact, you agreed.
Your Honor, I would ask objection to leading questions.
Judge,
You would
on
agree
redirect,
with
I am entitled to some leeway, especially in light of what counsel asked.
Not to leading questions.
Okay, let's not ask leading questions.
Okay, well, that didn't suggest the answer.
I know you can do it, Mr. Pease.
All right. Sir, you were interviewed by law enforcement?
Yes.
Yes? Okay. And in December of 2021 was the first interview?
Yes.
Okay. So you were asked specifically about certain things that were said in that interview. And you did tell the police in that interview that she said she was worried he might hurt himself or something like that. That was your type statement.
Yes.
Okay. And you repeated that again in December of 2023.
Yes.
Okay. And then you testified to that today.
Yes.
That's never changed.
Correct.
All right. So the very first interview you had with law enforcement.
Your Honor, objection to leading questions.
I didn't even ask the question.
Well,
The last 3 were leading.
he asked him, did you make this a statement in your written? Did you say this in your written statement? Yes. Did you put this statement? Did you testify to this? Yes. So I don't think that was leading.
It's not leading.
You told the police in December of 2021 about an extramarital
Yeah,
affair.
the female attorney's high strung. That's one way of putting it.
What did you tell the police about your relationship with Jennifer Crumbley?
Correct.
What did you tell the police?
Extramarital.
Okay. Did you give all the details?
No.
Okay. Did you tell the police how many times a week you would meet her?
No.
Okay. Did you tell the police about trips and specific times during the week?
No.
Okay. Now, why didn't you give all of those details in December of 2021?
Because I don't want those made public.
Okay. Are you happy about being here today?
No.
All right. What was your thought in withholding some of that information?
That it would protect people in my life, other people in my life, my family, my wife.
I imagine you've had some conversations since that time.
Yes.
Did you know how Jennifer Crumbley parented?
No.
Okay. Was that ever a topic of conversation?
No.
What was the topic of conversation?
You know that you met her in a Costco parking lot across the street from her employer. Is that right?
Yes.
Okay. And that would happen, as counsel said, during the work days
Correct.
and during work hours.
Correct.
Okay. And you don't recall how often that would happen, but was it a regular thing?
Yes.
You also told us that Jennifer Crumbley in that Facebook post told you she had a string lock. Is there such a thing as a string lock?
No.
Okay. You also told us that she told you that her son's friend committed suicide, and that the school didn't send her the original drawing. That's all those Facebook posts.
Yes.
Is that correct? Okay.
Correct.
And did you come to learn that those three things were actually not true?
Yes.
How big is your pole? How many women have slid down your pole? How do you like your pole to be polished?
Now, did Jennifer ever tell you the details about that meeting with the school?
Not that I recall.
Did she ever tell you anything about her son in the spring of 2021?
No.
Did she ever tell
The
you
Costco
anything
parking lot's a nice touch, yeah.
17th, 20th, 21st of 2021?
No.
Did she ever tell you about anything with her son's life in April of 2021?
No.
Did she ever tell you anything about her life in June of 2021?
No.
Okay. Did she ever tell you that she didn't have to be at a meeting later in the day on November the 30th, 2021?
No.
In fact, she was able to leave work to meet you when it pleased her.
Yes.
Yeah, the judge's interaction with the witnesses certainly is more than we've seen of
Sir,
any
when you were
trial we've
speaking,
seen in memory,
You
by
were
far.
told that we were not going to bring out the extramarital affair. Is that correct?
Correct.
Your Honor, objection.
I remember how much people were freaking out when I think it was Schroeder during Rittenhouse. I think Schroeder asked one question. And I remember how much everyone was freaking out that Judge Schroeder asked a question. Oh my God, Judge Schroeder asked a question. It's so biased against Kyle. You know, all the rest of it. Yeah, I remember. And here we have a judge who's like, well, let me just participate too in this thing. So shit.
As far as it goes with legal issues, that is not appropriate questions in front of the jury.
Why is that not inappropriate?
Well,
Because the prosecution's trying to allege that I've done something to put this witness in a bad spot when the evidence in this case requires the jury know all the information.
I think his question is directed at the fact that Mr. Malash was probably taken off guard when he testified today. Isn't that what your question's about?
Yes, Judge.
Yeah. You didn't know you were going to be asked those things.
No.
Okay. Jennifer wrote to you that she felt like she failed as a parent
That was in the message.
in the messages, yes.
Yeah, judges ask more trials in the bench trial. That's very true. In the bench trial, they tend to be more active. That's fair.
Tell you anything about the background?
I'm not sure we've ever seen the bench trial.
Her husband.
No.
And again, I just want to make something crystal clear. In the interviews you had with law enforcement, nobody ever told you that you would be fired, correct?
Correct.
No one ever told you that you had the risk of being fired.
Correct.
What were you told to do when you came to court today?
And tell the truth.
Okay. And have you told the truth?
Yes.
Correct. Thank you. If nothing further.
Your Honor, may I have two questions?
Yes.
Okay, Mr. Malash, it's fair to say you testified earlier you have memory issues.
Yes.
Okay, describe those memory issues for this jury.
Judge, that's been asked and answered. It's beyond the scope of my redirect. And unless we're going to go through all the prior consistent statements.
I'll withdraw that question. Earlier when you testified, and this is my last question, you did say you had feelings that there was pressure on you about certain areas of your life being affected by your statements to police,
Hold on,
correct?
Judge. That's mischaracterizing the testimony. He's testified multiple times. He was not threatened.
Okay, well, she didn't ask that.
I
She
asked-
has asked that.
Well,
I
you
did
know,
ask that.
I've gotten a little bit of inconsistent. I don't know if it's testimony or vibe from you. Did you at any point, you said the police didn't threaten you, but
There were veiled threats.
well, I asked that. Did you feel like there were any veiled threats? He said yes, but he didn't tell me what those were. So, you know, did you feel pressure to tell the police some things? And if so, what were those pressures? You said that your job wasn't threatened.
Yes, Your Honor. Can I specify what I was trying to do to clarify?
Please.
I tried to clarify. I felt I was guarding myself in my statements, and the investigator was pushing it and inferring that this would all get out, which it has now with what was going on. He didn't threaten my job. He was asking questions that were professionally related. Because I know he was trying to establish some sort of rapport with me because he worked in law enforcement, so he was asking about pensions. He did get more aggressive with it, and it was threatening as in personal information getting out about me out in the open to the public and stuff.
Okay.
I shouldn't say stuff, but did that help?
Okay, do either of you have any questions based on that?
I do.
Okay.
Did he ever tell you to say something that wasn't true?
No.
Okay, you were told to tell the truth.
Yes, sir.
Thank you.
Anything else?
You were asked questions repeatedly, the same question over and over, as we've done in this courtroom today.
All right, just step down and you're excused. Okay, tell me what we're doing next.
Well, that was a thing. That was definitely a thing. Woof. Yeah, no, it's not extortion. It's not threatening. It's just like, he's just pressing for more details. He's pressing for more information. And he's saying that it's going to all get out there, which is pretty fair anyway. And that's not extortion. Yeah, it's fine. It's legal. Yeah, it's fine. I don't really know what the point of that was. I don't know if the point was to humanize the defendant. I don't really think it accomplished that goal. It just made her seem untrustworthy, unreliable. I don't really know what just happened. I'm very confused. Uncivil doesn't understand things. Uncivil is very weird. I don't get it. I've got nothing intelligent to say. I'll tell you what, if any other legal commentator has any intelligent thing to say about whatever the hell that was, if someone would like to tell me, that'd be great, because I could use a different perspective. What the hell was that we just watched?
We have a witness, right?
Did you guys need a break? How long is this witness, do you think?
They weren't suggesting, the police weren't saying that they were going to release it.
Okay.
The police were just saying the information was going to get out, which, you know, is a reasonable prediction.
Okay.
All right, for the jury.
All right, let's scroll forward in time and see however this day ends.
Approach after the jury, excuse me.
Yeah. I want to ask you something too.
What are they doing now?
You may be seated. You know, before the trial started, there were some issues raised about privileged records of the shooter and Fifth Amendment rights of the shooter. And I've had some filings from doctors, lawyers, from the lawyer for the shooter, and also by Ms. Smith. So she filed something, and I know that you responded today to it. I guess I feel like I've ruled on those issues, but I wanted to give you guys as much opportunity as possible, because as we've established, there is not a lot of law in this area, and I've personally not found any law that would allow me to pierce a privilege possessed by the shooter. But that being said, I think you filed a response, and then there was maybe a confidential attachment to that maybe was directed at some of the contents of the privileged documents. But I have not received that. That's the long and short of it, as I have not received.
They were trying to get Ethan on the stand, yes. That was one of the things they wanted to do.
I didn't know that. So.
One moment.
check on the status. It was being
Okay.
sent by Mr. Williams.
Okay. Okay, so what else? You wanted to approach about something?
Yes, sir.
Okay.
Okay. And then we just go to seal for a while, and we'll come back to not seal. Why couldn't he testify? He took the fifth. He took the fifth.
Please state your name for the record and spell your first and last name.
No problem. My name is William Creer. William's common spelling. Creer spelled C-R-E-E-R.
Right, go ahead.
I misspoke and called you officer, which is probably a good way of introducing you to the jury, but I'm just going to call you Mr. Creer.
That's fine.
You are not an officer. What is your title?
Forensic technician.
And who do you work for?
Detroit, City of Detroit Police Department.
Okay, can you explain to the jury how you work for the City of Detroit Police Department, but you're not an officer?
I'm a crime scene investigator. They send me out to the scenes, I collect the evidence, I take the pictures, package the evidence, and I come testify in court.
And how long have you been doing that?
20 years.
So is your title forensic lab tech?
No, just forensic technician.
Okay.
There's a difference. Lab techs, actually, the people that test the evidence I collect, I just go collect the evidence.
Okay, you don't work in the lab.
No.
Okay. So is it correct to say that you're a civilian working for the police department?
Yes, ma'am.
All right. I want to direct your attention to December 3rd of 2021. Do you remember that day?
Yes, ma'am.
Were you working?
Yes, ma'am.
Were you at some point dispatched to a building with the address of 1111 Bellevue in Detroit?
Yes, ma'am.
And were you made aware there was a search warrant being executed at this location?
Yes, it was.
Okay, how many times have you, roughly can you estimate, gone to a crime scene and collected evidence?
A lot.
Okay,
What's the actual number? More than 1,000.
Okay. Did you go with anybody or were you by yourself?
I had a partner that day.
Okay, and what was your partner's name?
Forensic technician Stephanie Sparks.
What were your initial thoughts as you headed to the location?
When my partner and I were heading to the location, it was just a normal search warrant. Collect a picture, take pictures, collect the evidence. And then when we arrived at the scene location, we saw the media cameras. And that's when we figured, okay, this is going to be a little bit more than a normal search warrant.
Okay. Who did you speak to when you arrived on scene?
Lieutenant Hall.
And why Lieutenant Hall?
Because he was the highest ranking officer at the scene when we arrived, and we got the request over the radio. He was the one that dispatched the officer dispatched the request for the scene to be processed.
Okay. And what did he ask you to do?
When we arrived at the scene, we went into the building, and that's when we were made aware that this was regarding the Crumbley case and how we were going to execute the search warrant.
Okay. Is it correct to say that you process the scene? Is that how you would describe what you do?
That's exactly how it was described.
Okay. And when you process the scene in some crime scenes, does that mean something, the depth in which you perform those duties, does it differ depending on what the law enforcement wants you to do, or is it the same every time?
We work hand in hand with law enforcement. Officer in charge usually goes in or has already secured the scene with the other officers. By the time we arrive, they have an idea of evidence they want collected. When we arrive, we do a walkthrough with the officer in charge or the detective or whoever is the highest ranking officer on that particular scene. We do our walkthrough. He points out evidence that's important to be collected. While we're doing our walkthrough, my partner or whoever I'm working with that day will point out items that we believe might want to be collected. And then at that point, we start taking pictures, documenting the scene, and collecting the evidence.
Okay, so do you only collect the evidence they point out you need to collect this, or do you determine based on your own experience what what you should collect, and how do you ever collect anything that's not visible when you first walk in and law enforcement directs you to?
After we do a walkthrough with the investigator, and then if they give us permission or we agree that we're going to do a more thorough search and we see some items that we might want to look at a little bit more thoroughly, then we will do an additional search of the scene.
Okay, so the items that you find, does that lead you to the other parts of the scene that you want to search, or do you search only what the law enforcement tells you to?
Again, depending on how things operate. In this particular scene, we use this particular scene as an example. They had already initiated their search. They had already found items they wanted. At this point, they said, hey, if there's any additional items you two see or might want to go over, have at it.
Okay, so you were given free reign of the entire room?
Yes.
Okay. Is it part of your protocol to just collect what you see out in the open, or do you actually do you conduct searches?
We conducted search in this particular case, yes.
Okay. Is that something routine, or is that unusual?
It varies by scene to scene.
Okay. When you walked into the room, what did you observe?
Again, a search warrant had already been executed. We took our overall pictures of the scene. We saw, items that were already collected from or found by law enforcement. There was foodstuffs on the table, just as you directly in front of you, mattress and clothes scattered around the room that had already been found.
Okay. I'm going to show you pictures in just a moment, but I want to, with your permission, get a little bit more detail about the things that you first discovered. When you just said you saw some food stuff. Do you remember specifically what you saw?
I believe bananas, jug of orange juice. I want to say maybe alcohol. Say possibly vodka. That's all I can remember off the top of my head.
Okay. Did you see anything else that stands out to you right now?
No.
Okay. Okay. I'm going to show you well, before I do that, can you describe what did you think that room was when you walked into it?
When I walked into it, I was an art studio of some guy.
Okay.
So I remember portraits and just art stuff around the room.
All right.
Tables, kind of reminded me of an art class or something like that.
All right. Did you see anything else on the floor?
I saw a mattress.
And what did you think of that?
Apparently somebody sleeping on a mattress.
Well, I'm sorry, you
It looks like somebody sleeping on a mattress.
Okay. I'm not sure. I know I didn't ask you this. Did you have contact with Jennifer James Crumbley when you were searching the room?
No, at the time, no. They had already been arrested and I believe taken to open county jail.
Okay, so you didn't see them?
No.
All right. So I'm going to show
Not
you.
at that particular time.
Right, we're going to get to that.
Okay.
I'm going to show you some pictures, and then I'm going to pull out just 2 or 3 things just for demonstrative purposes for the jury. But these are photographs, exhibits 348 through 400.
I'm sorry, 348 through 400.
So on the exhibit list, they're listed from 348 and the
348,
the description.
351 were previously admitted, but 350 has not come in.
I'm just checking. We have no objections on these. Thank you.
Okay. All right. So tell the jury. I'm going to just go through the pictures, and you can, if you will, just describe what we're looking at.
That's the scene location.
I'm sorry, Mr. Greer. About what time did you arrive on scene?
Around 2:40.
A.M.
Yes, ma'am.
Okay. Were you just working the night shift, or were you at home, or where were you when you got home?
I'm assigned a midnight shift.
Okay, gotcha. All right, so this is what?
That will be the crime scene location.
It should be on your monitor, is it?
Oh, yes.
Okay, great.
I'm just so used to it.
Yeah. All right.
That's the scene on Bellevue. That's another angle of the scene on Bellevue.
Okay. Can you go back one? Can you see the windows of the art studio that you searched in that photo?
I don't recall.
Okay, next photo. Does this look familiar to you?
Yes, ma'am.
Can you tell the jury what this is?
So those are the reporters that we saw when we were pulling up, and we asked them to move so we could take pictures.
Okay, was that something common that you encountered?
Yes.
Okay. Next. What is that?
Again, we're at the crime scene location, the exterior shot.
Okay, and the next.
That would be the vehicle we're also allowed to, requested to photograph.
Okay. So did you take these photos?
No, a partner took these photos.
Were you there when she took them?
Yes, I was.
Okay. What is that?
If you zoom in, you can see cigarette butts that we were requested to collect.
Okay. And what are we looking at?
Looking at more cigarette butts we were requested to collect.
Did you know why you were requested to collect those?
Because of possible DNA evidence.
Okay. Next. What is this?
That would be Suite 130, the crime scene location.
So the art studio was Suite 130, or actually, is 130 the art studio you searched? I'm sorry.
130 is the art studio. We searched the actual crime scene address was 1111 Bellevue.
So the building was 1111 Bellevue.
Yes.
Okay. And the art studio was what?
130.
Okay. What is this?
That's inside Suite 130.
All right, and the next picture?
Again, we're inside Suite 130. These are overall shots of the entire room. So you get an idea of the items in the room and the room in general.
Where, in relation to the door to the studio, is there one door or more than one door?
There was just one door in and out of this room.
Okay. Where in relation, in this photo, where's the door?
The door is, from this angle, the door is directly behind and to the left.
Okay. And the next?
Again, we're kind of circling the room with overall shots.
Okay.
Again, the door is behind and at this point behind and to the right.
Okay. What is this?
Again, we're taking overall the room. The door is directly behind us and we're taking a shot across the room.
Do you see a mattress in this photo?
No, but if you go back, I believe you can see the mattress there at the bottom of the screen. The two drawers are on top of the mattress.
Okay. Right. And the next photo?
Again, that's the shot from across the room. The door in and out of the room is directly behind the part to take the photos.
Okay. And the next one is 360. This is just a different view.
Different angle.
Is that the mattress there in the right bottom corner?
Yes, ma'am.
Okay. Did you put those drawers? Are those drawers?
I believe they're drawers, and they were already there at the time that we arrived.
Okay. And 361.
And then you have a better photo of the mattress and the drawers.
And the next. Okay, what is this?
Now we're circling around with a photo of the mattress, a plaid object, and whatever cover that the mattress is resting on.
Okay, in a minute we're going to get to the actual items individually, photos. But did you take pictures of those individually at some point?
I would have to go through the pictures to make sure. I'm pretty sure we did.
Okay. And what's your recollection? What is that? And you said it's an item. Is it a blanket? Is it a piece of clothing? Is it something else?
I believe it's a clothing, a plaid shirt.
Okay. 364. What is this?
Again, we're circling the room. As you see at the top right-hand corner, that's the table with the food items on it. You see the orange juice at the top right corner and a bottle of Coke. Bottom left corner of the room, you have a Snipes clothing bag.
Okay, right next to the orange juice, that circular object on the counter there. What is that?
Right next to say it again.
There.
Oh, those are solo cups
Okay. And
or plastic cups.
365. What is this?
Oh, those are photos of the clothes that was inside Snipes bag.
Okay, can you tell the jury what those are?
A few pairs of socks, a sweatshirt, and again, you have the plaid item in the baseball cap that was in the previous pictures.
Okay, and are the socks attached to anything?
They're attached to, just like you would buy them from the store, paper that would connect the socks together.
So they're new?
Yes. There's also the receipt in the picture, just by the sweatshirt.
Okay. And do you, I think there's a closer photo of that actual receipt, which we'll get to. 366. What is that?
This will be by the mattress. Between the mattress and the shelf is like a pink shirt.
Okay. And 367.
And there's a better picture of the pink shirt.
So, did you or somebody else take it and lay it out like that?
Yes.
Okay. 368. What is this?
It's another shirt.
Where was that found?
Can't quite remember off the top.
Okay. Do you need to see? Did you write a report?
I did write a report.
All right. Would that refresh your recollection?
It would. Thank you.
Okay. Mayor Pro Charter.
Sure. Thank you.
This guy's cadence is like, I don't know, something about his cadence is just rubbing me the wrong way. It's like too cheery. It's just like, I don't know, something about it's just off. Can't be just me. Also, why do we really need the tech to tell us about all the things that were found there? Is that going to help?
Yes, it was in one of the plastic bins.
Okay. That shirt was in a plastic bin?
Yes.
Okay. I think if we proceed through the photos, that this will make a little bit more sense. Okay. Is that a plastic bin?
That is one of the plastic bins, yes.
Okay. How many total plastic bins did you find items of interest in this search?
I believe 2 plastic bins were during the entrance of the search.
Okay. Were they in the same place or were 2 different places?
They were in 2 different places.
Okay. Where was that plastic bin?
That plastic bin was along the north wall of the room, under the table with food items on it.
Under the table, right there.
Right.
And so, correct me if I'm wrong. Is the mattress on the other side of this table?
The mattress is on the other side of the table, yes.
Okay. Was the plastic bin found like that with the lid off and the backpack sitting up?
No, we looked at it. It looked funny.
Sure they weren't planning on handing themselves in? I guess it's fair. It's fair.
The top was kind of ajar, and that's when we found the bag and the lid.
Okay. And we're going to get to the contents of what was in that backpack in a moment. Can you flip to 370? Okay. What is this?
Again, that's the table with all the food items.
All right. Can you describe to the jury what you see, all the items there that are on the counter?
No problem. You have the bananas, you have container of orange juice, container of burners, a box of Special K, and a bottle of water, along with some solo cups or solo-like cups.
Okay. I see some paper towel there.
Yeah, there's a paper towel and a box of Kleenex.
And Mr. Keese is going to sort of highlight some of the other items to ask you what those are. If you know what is that?
A box of can't quite make it up.
Okay. Do you want to look at your report?
Yeah.
That refresh
Who
report.
cares what it's a box of? Is it a box of flour? Is it a box of cookies? Is it a box of dicks? I don't care.
My report says food stuff items.
Okay.
Food items.
Wow, that was insightful. That was insightful. Can we go to the report to check? Yes. The report says foodstuffs. Wow. Really glad we spent the time on that.
Okay.
Papers, food items, plastic cups, and plasticware.
Okay, so those are boxed something.
Yes.
Okay. If I told you that says Lara Bar on it, would you have reason to dispute that?
No.
Do you know?
Looks
what
like
that
Laura
is?
Bar.
Okay, they're granola bars.
Okay.
Or energy bars.
Okay.
Okay. So you've never had a Lara Bar.
I've never had a Laura bar, no.
Okay. What is the next item Mr. Keast is showing with the magnifier, if you know?
Bottle of lotion of some type.
Is it lotion or is it shampoo?
I believe it was lotion. But
Okay. What is that?
I'm not sure.
What does the bottle say?
Remove?
Minute Maid?
Oh, you're talking about the plastic bottle behind?
Yes. Yes.
Yeah, that's a Minute Maid.
Okay. And then there are 2 other cups right there.
Yes.
Is that the way you found it, or?
That is exactly how we found it when we were
Okay. All right. Next. This is what?
That is, again, a plastic bin with a pink tote bag inside.
Okay. And the next photo? What is that?
It's a plastic bag. We removed it from the plastic bin. I mean, the pink bag we removed from the plastic bin.
Okay. What are the items to the left?
Those are improved.
Did she have some Lululemon?
Okay.
I mean, a pink bag.
Did she have Lululemon? I'll convict her for that.
Describe to the jury what you found in the pink backpack.
In a pink backpack, there was a second bag and various clothes.
Any woman who wears Lululemon is guilty.
Intimate clothes, underwears, etc.
Okay. Men's underwear or ladies' underwear?
Ladies' underwear.
Do you know how many pairs?
About 4 pairs. if I
Okay.
recall correctly.
And that gray item next to the pink backpack to the upper left, what is that?
That's just another bag that was inside the bag.
Okay. And 373? What is this?
Again, we have another angle of the pink bag, the gray bag, and a pair of pants that was also inside the bag.
Okay. And 374?
We have another angle of the pink bag and a pair of the dark colored pants.
Okay. The green bag underneath the pants, was that found in the yes. Was that found in the backpack?
Yes.
What did it have inside of it?
I don't recall.
Okay. I'll hand it to you in a minute.
Okay.
Next slide.
Again, we have a picture of the brand of pants, the fact that they're stretch, and the size on the tag under the false boot.
Did she have boots with the fur?
Next slide. What's this?
Again, we have more of the intimate items, intimate clothing items, and a plastic bag with,
That's a business card?
yes,
Okay. And what's next to it?
several pills inside the container. I believe they're caffeine pills.
All right. And the next picture?
Again, we have a closer picture of the business card and the pills.
Okay. And then 378. What is this?
It was an ointment container and an injectable medication of some kind.
And where was it found?
It was all of that was in a plastic bag, which was inside the pink book bag.
Okay. Were you able to determine whether those were for human beings or horses?
For horses.
Okay. And the next slide.
We have another picture of the intimate female clothing and more clothes. And also the green bag that you asked about earlier.
Okay. What is this?
It's a key card
And what is?
for an extended stay in America.
Okay. Where'd you find that?
It was inside of a jacket over the chair. If you go back, way back at the beginning of the pictures, you will see a black.
I don't think those are caffeine pills, by the way. They're too big to be caffeine
Next
pills.
slide. What is this?
This is inside of a garbage can. It was near.
They could do better in their whiskey choices, I suppose.
It's a whiskey bottle. There was a few pictures before that I didn't see us go through that showed what the garbage can was in relation to the table of food items.
Was the bottle empty, or did it still have?
They look like sucrettes to me. Those large things in the container. They look like sucrettes.
It's a receipt from Rivertown Market.
And what does the date and time say?
I can't see.
I'm not sure it shows it in that.
Yeah, I'm not sure it shows it in this
Okay.
picture.
All right. The next. Okay. What is this?
It is a bag of ice, and there's also I can't quite remember what fruit that's in.
If
One
it's
lonely avocado?
It's an avocado.
It's-
It is one lonely avocado with some ice.
So you said there were just 2 bins. Is this the second bin?
Liverin,
Okay.
you think?
Where'd you find this?
It was, if I remember correctly, this bin was.
Yeah, throat lozenges, yeah. Looked more like that.
We're gonna go back and
West
show
wall.
a picture of the whole room again when we go through each thing, but this was in the room that night, correct?
Yes, ma'am.
Okay, was the ice, can you go back to this, to the receipt? What is, can you read if we give a close-up what the.
And
items
packages
on
for
the receipt
Vivarin?
were?
Fair enough.
Bagged ice, a Larabar, 2 Larabar.
I really prefer no dose to Vivarin, though.
Clo cup.
I'm an old school guy.
A nut tray, orange juice, Diet Coke. Paid a deposit, I believe, probably for Diet Coke. Organic bananas, extra large avocados, and an ice mountain.
Okay. When you, what is the ice sitting in?
It's sitting in a metal tray.
Okay, a receipt later says lasagna pan. If you know, would you call? You don't know, do you?
I would call it a metal tray.
Okay.
I would not call that a lasagna pan. I've never seen a lasagna pan that looks anything like that.
Large.
Has anyone seen a lasagna pan that looks anything like that?
Was the
That's-
ice melted or
Lasagna pan.
tapped?
It was melted.
Okay. Next picture. What is this?
It is the receipt. I believe it's the bottom half of a receipt.
What's the date and time?
12/3/21. 4:09 p.m.
Okay, and that's looks like it's for how much? If you can see, does it say
No, I don't see it. I'm not seeing it.
up at the top?
Sold items, $1.04.
Okay, and it's to the state of Michigan.
Yes.
Okay. What is this?
It's photograph of the mattress that we
I
went.
think it's a store deli lasagna pan.
Item at the bottom.
Okay,
of the
I'll take your
screen.
word for
What
it.
is that?
It's a blue solo type cup, plastic cup.
Was there anything in it?
No.
All right, and 386. What is this?
That's another plastic bin.
Okay, so were there 2 plastic bins or 3 plastic bins?
There were multiple plastic bins
Okay.
in the room.
The items that you found, were they in 1, 2, or
Can we
3
go
plastic
back to
bins?
arguing about what's in
Okay,
Heller
So there's the one
and Bruin,
the
please?
backpack
Because
was in.
at least then I felt
was in.
alive.
And then what's the other one?
That second plastic bin was with ice that was melted.
Okay.
And we have this third plastic bin that actually, which I would say the second plastic bin, which actually has items that are imported to this.
Okay, so you weren't counting the one with ice?
No.
Okay. All right. Where was this located?
This will be alongside the west wall.
So was it next to the mattress?
No. The mattress, again, as you come into the room, you have the table that had food items on it, and then you have the bed. As you work your way further west in the room, you have that wall that you took, that we go through the earlier pictures, had the picture with the paint splotches or whatever.
All right. Well, I don't mean to interrupt you, but we'll show you a picture.
Okay.
So was this next to the other bin with the backpack?
No.
Okay. About how many feet away from that bin was?
You know, if I didn't know better, I'd say it kind of looks like an artist's studio.
About more than 8 feet.
Okay. And what was inside this bin?
It was a purse.
Was this securely latched?
Yes. If you
Alright.
go back to the further picture, you can see how it was more firmly latched.
Okay. And did you pull that bag out?
Yes, we took the pictures in sequence so you can see us removing, opening up the actual plastic, the plastic bin, and then actually pull it out first.
Okay. And the next slide. Is that the bag that was in the bin?
Yes, ma'am.
And
If they go through every one of the items in the bag, I'm going to lose my
I
shit.
don't want to put words in your mouth. How do you approach the photos in terms of sequence?
Well, as we go through the purse or any kind of item that there's item.
Please don't tell me you're going to go through the itemized items of the purse one by one.
How the items are in the purse at the top of the collection. And then we start pulling out the items and kind of setting them up and showing the items individually that was inside the purse, bag, whatever.
Okay. Let's go to the next slide and we'll go through all of the items because you actually take each item out of the purse.
Oh my
correct?
God.
Yes.
Okay. What are we seeing there?
Those are 2 envelopes with cash inside.
Okay. And 390? Oh, I'm sorry. What's underneath the envelopes?
That is the top of the tabulation return. Whenever we do a crime scene, there's an officer there that takes notes on all the items we collect from the crime scene.
Okay. Look closely at that search warrant tabulation. Who's Peschke? Do you know who that is?
No.
Okay. If I told you it was an Oakland County sheriff, would you say that this was the search warrant for that room?
Yes.
Okay. Is it continuing? Okay. There were two search warrants. Well, there were many search warrants executed that day. The search warrant that was executed on the art studio was one of them. There was also a search of the defendant's home.
Okay.
Do you know whether this was a tabulation for the art studio or the defendant's home?
This should be a search warrant for this location, this scene location.
Okay, we'll get to that. Next. What's this?
Again, we're taking more photographs inside the purse.
And what's visible in the purse?
Most visible is you have more cash. Cash inside the purse.
Okay. And then some other items?
Yes.
What's to the right?
You have pills, bottles of pills.
And then what are those items?
Along where, if you there you go. You have the keys, and as you go further to the right, you start to see the cell phones that we also collected.
Okay. Next picture. That's a close-up of the cash?
Yes, ma'am.
All right. And 392?
No, you have a close-up of the pills and cell phones, and also the keys to the Kia outside.
Okay. How many cell phones?
4.
All right. And did you notice anything about these cell phones? Well, first of all, were they on or were they off?
All the cell phones were off at the time of we collected.
All 4 of the cell phones were off?
Yes, ma'am.
Okay. Anything else did you notice about the cell phones?
As you see, one cell phone is, as I say in my report, severely damaged.
All right. And is that's the front screen?
Yes.
Okay. So would you say that's multiple cracks indicating damage or a couple of cracks?
I'm comfortable with saying severely damaged.
Okay. Next. That's a close-up?
Close-up of the keys that we collected from inside the purse.
And what is that card, if you know?
Look, it says card activation. It's like some kind of bank card or some kind.
Okay. Next slide. All right. This is a close-up of the medications.
Mm-hmm.
All right. And can you read what the medications? First of all, are they prescription?
They are prescription.
And who are they prescribed to?
Jennifer Crumbley.
All right. And do you know what each prescription bottle is for?
You have 2 bottles of Adderall, and then the third bottle I can't quite make it out.
Okay. I'm gonna close up there. What is that?
Alloproxolam.
All right. Do you know what that is?
No.
Okay. If I told you it was Xanax, do you have any reason to disbelieve that?
I would have any disagree. No.
Okay. All right. Next.
Again, we have photos of the cell phones.
Okay. And the next one. What is this?
That's when we started pulling out the cash and counting it.
Is that your protocol? You lay out all of the bills?
Yes.
Okay. 397. That's
We're continuing to count the money as we find it.
okay.
And we're still counting money. And we're still counting money. That's the last photo of money.
All right. Did you count all the money?
Yes, we counted all the money.
What was the total in cash that was in the purse?
$6,617.
Okay. 400. What is this?
It's another photo of the receipt. I believe that's the top section of the receipt from earlier.
And what is the date and time?
12/3/21, 4:37 p.m.
Can you read the items on the receipt?
No problem. Jeffrey giant lasagna pan, burners 2 liter, got a recycling fee overcharge.
That is not a $1 lasagna pan.
Kleenex Ultra Tissue.
Okay.
Thank you for the super chat.
All right. Lieutenant Melissa's going to help me just for demonstrative purposes pull out just some of these items that are not exactly.
I don't know why you would do this. Why do we really need to go through every single item they had with them?
This was the item that you photographed. Is that
Do we
right?
really care?
Okay. The first is the book pack, the backpack.
Yes, it does appear to be the photograph.
Okay, we're now showing the backpack. We have brought the backpack into court so we can do show and tell.
And that's where the packet is with the horse medication. It looks like, was this in the backpack?
It was in the back.
Okay, and then the clothing items were also in there.
Yes, ma'am.
Okay. And then the next,
That's 427 for the record, Judge.
427.
okay,
What's 427?
For demonstrative purposes, the backpack. So it's identified.
I'm going to need a higher proof alcohol.
you recognize these items?
Yes, that's the.
I wonder if I add bourbon to my
Okay, so are they
Kahlua.
clothing or are they blankets?
They appear to be blankets.
Okay.
Are those also 427?
Bailey's mix, if that will work. Does bourbon go with Kahlua and Bailey's?
That's the Snipes bag, correct?
Yes, ma'am.
Okay. Those are the socks. I'm just gonna get that. So these are some. Where did this is? What is this?
That's the sweatshirt. We already went over it through the picture, with the pictures earlier.
And where was that found?
That was found near the Snipes bag.
Okay. What is this?
That was the jacket that was over the chair.
Okay.
That had the hotel room on it.
Okay. And then the only, that's those are just items you have to come out. And then the only other thing we're going to show you is the last item found in what you call the second plastic container, which I call the third.
Cheers, everybody.
Is this that in that container?
Yes, that's the first.
Okay, and were the cell phones found in this bag?
Cell phones, the money, yes, that was in the bag.
Okay, thank you. All right. Before I go back, lastly, to show you the pictures of the room so you can orient us on where these things were found. Did you ever come in contact with Jennifer Crumbley?
We were requested to look out of jail to photograph both the properties.
Okay, and why were you asked to do that?
We were just requested to take pictures if there are any injuries regarding their arrest. Because the request was not only for the search warrant, but if you look at my report, the request was to process the scene of a search warrant and arrest at the address at 1111 Belvedere Street.
Okay. Do you see Jennifer Crumbley in the courtroom today?
Yes, I do.
Can you point her out and describe something she's wearing?
She's right there, and she's wearing a blue jacket, or a suit jacket.
May the record reflect that he's properly identified the defendant.
The record will say.
Okay, lastly, I just want to take you to the initial photos that you took to the room to try to point out where exactly you found each of these plastic bins.
He does kind of look like he works at a club, yeah.
Okay. Right, is this a good photo to show us?
Yes.
Okay.
Go back one more. One more. There we go, right there. The first bin is going to be to the just to the right of the food, the table with the food items on it, on the floor, and it was kind of under the table. That was the item that had the book bag in it, if I remember correctly.
Next time I'm going to go to the liquor store, I'm going to get myself some rum chata
Exactly.
Okay.
to mix
Where
with
was
the
ice and the avocado?
Kahlua.
Ice and avocado.
And then I think I'll add a little Sailor Jerry's to that. I think that could be fun.
Of the first bin.
Okay. Was the second plastic bin that contained the purse with the cell phones and the cash, where was that?
If you look straight ahead, as I mentioned before, the portrait that had the paint splotches along that wall, you have that table just up under it, and just beyond that, when you move around, that's where you see the container with the
behind
Yes.
that workbench on the left?
Yes.
Is there a better photo of it? Can you see it from that?
No, we're looking
About there.
Come around. That area, just one more over. There.
And right now it's just
Yeah.
Bailey's and Kahlua, so it's like a poor man's
You have the
White Russian.
the yellow
Good.
section
Cart?
of tub, the yellow cart with the tubs on, with the tubs.
Yes.
Just to the left of that, you have the items with the paint, and then just behind that would be the tote.
Okay. And that was securely fastened?
Yes.
I like whiskey and bourbon too, make no doubt. I just wanted something different last time I went to the liquor store.
As you, when you go through the pictures, you can see that that bin is in another.
Was the bin inside that bin also closed?
No.
Okay. And was the bag zipped or unzipped?
Bag was at the time when we collected.
Okay. And that's where you found the cell phones that were turned off and the cash?
Yes.
Okay. And how did all of that evidence get here?
After we took pictures, all these pictures, we then collected the evidence and we secured them in these items and turned them over to the Detroit Police Public Safety Headquarters in the evidence lockers.
Okay. Thank you.
No problem. Thank you.
Oh,
Oh, definitely.
I guess we're done.
And I'm like, man.
Oh, I guess we're done for the day. Okay, that was sudden. All right, well, I guess we're done for the day. Okay, well, that was fast. All right. Well, all right, that was just very sudden. No, you guys have no audio. I have no audio either. It's not me. It's just this feed. There's no audio. Or if it is me, I don't know. But they dismiss the person. Everyone stands up. So it looks like they're done for the day. Yeah, they're done for the day. Yeah, the feed stopped. So they're done for the day. Okay, well, that was the end of that. All right. Well, that's that, I guess. This just stopped like it right in the middle of something. So, okay. Well, that's a thing that happened. All right. Yeah. There's no audio. It just the audio stopped and it's like just stopped.
Turn them over to
Evidence get here.
after we took pictures, all these pictures.
It just stopped
Then collected the evidence and we
and
put them in these items and turned them over to the
then like
Public Safety Headquarters in the evidence lockers.
what, 15 seconds later,
No problem.
everyone stands up and we're just done for the day.
Thank you.
Okay, well,
Oh, definitely.
you can hear it.
And I'm like, man.
You're right, it is popping up. It's just not showing up for me. You can hear it, but I can't hear it for some reason. Well, everyone stands up because it's like over.
Certainly tomorrow afternoon.
Oh, is it on the other earbud? Is that what it is? It- I can't hear anything. Oh, there it is, sort of. Yeah, it's like I can only hear it in the right channel. I can barely hear it in the right channel. Well, it doesn't matter. They're done for the day. So it doesn't matter. We're done for the day. So yeah, it doesn't matter. You only missed like 30 seconds of actual thing. Yeah, because the feed stops after that. So they're done for the day. Yeah, the feed stops 2 minutes later. So we're done for the day. All right, cool. So you missed like 1 minute worth of whatever due to some audio issue I can't resolve. So we're fine. You didn't miss anything important. Yeah, so we're done. We're done for the day. All right, so we'll be on tomorrow, I guess. I suppose the state's case is resuming because the state was still in the middle of questioning him, and unless the defense is like no questions. So I don't know where we're at. I don't know where we're starting tomorrow. So I don't know if we're still with the state's case, but we're definitely going to pick up the defense's case tomorrow. Either way. So either defense will start in the morning or short thereafter. So the state's case is at an end. So yeah, paralegal Liz better come here on Friday. We need to get enough money on the channel so I can hire paralegal Liz full time. That'd be good. She could be my full time paralegal. Be good. Three witnesses left for the state? I thought they said they were done today, like with the witnesses. Three left? All right, we'll see. They're bringing in more people she's sleeping with? Yeah, maybe. All right, guys. Well, we're done for today. The court said they want them back at 8:30 tomorrow, so they're going to start at 9, presumably. So that means I have to get up for a 9 o'clock stream. So that's okay. The judge told your boss you need a raise? That's cool. That's cool. Yeah. Gonna go for a workout? Nah, I got other things to do. I got to film today at some point. I got some filming I need to do today. So I'm gonna take a little break and then I'm gonna film. And go from there. All right, guys. I guess we're done for the day. So I will see you tomorrow on Uncivil Law. I hope you all have a great one. Bye-bye for now.